Welcome, everyone, to this Standing Committee of Justice and Human Rights. It's wonderful to see the interest in our committee. C'est grandement apprécié de voir tout le monde qui est ici.
We appreciate seeing so many people here today.
In the House of Commons, because a lot of people watch Question Period, and they only see the interaction of parties at Question Period, where there's a lot of gamesmanship. And this committee actually does really good work. We have worked together on a study on the Court Challenges program that helped bring back the Court Challenges program. We worked together on a legal aid study. We worked together on a study to help Canadian jurors that led to my colleague, Mr. Cooper's private members bill that will be coming to committee in another week that will make things easier for jurors to disclose information to a psychotherapist and analyst about their jury deliberation experience. And where we haven't agreed on issues, we've done so with great courtesy. And so, j'espère bien qu'aujourd'hui on va.
And I hope today that we'll continue in that same spirit. There are many new people here today. Everyone is welcome.
Time when Canadians are watching us, and I think they're expecting to see a committee that functions very well. The issue that brought us here today, my opposition colleagues have asked for a special meeting to be held, which we happily have convened, to discuss a very serious issue before Canadians. Canadians are rightly concerned right now about the issues related to the former Attorney General. And definitely we, on our side as well, want to make sure that Canadians understand what has occurred. We were a little disappointed that the opposition went ahead and drafted a motion without consulting us or working with us, but I get that's the way politics works. We're hoping to find a consensual way to bring this subject to Canadians, and I'd like to ask my colleague, Mr. Boissonnault, to perhaps put forward something that I think will draw the consensus of everyone.
Well, thank you, Mr. Chair, and I think that it's nice to see so many people here today taking an interest in Canada's justice system. I think it is clear, Mr. Chair, that there is concern among Canadians in terms of how we got to where we are today. And I also think it's clear that the Prime Minister has been very clear in his interactions. And I think the Justice Committee has a responsibility to reassure Canadians that our justice system is not only intact but robust, and that our government follows the rules, and that we take pride in doing so. And I think there is some concern on our side about the sub judice rule, that we have to be very careful as a Justice Committee to make sure that anything that we would undertake here as a committee would not affect any court proceedings related to SNC-Lavalin or any other parties who may be subject to court proceedings in the future. And so this motion today is designed to address the confidence of Canadians, to reassure them, and to shine a light on what remediation agreements are, what the Shawcross Doctrine is, and what the discussions were between the Office of the Attorney General and government colleagues. And so I believe, and my colleagues believe at this point, that this is an appropriate motion at this time, and you should have copies of the motion in both English and French that are being distributed. If not, then we will make sure that is done right now.
Have we gotten the French version yet?
Yeah, it's right here.
Okay, so Monica-Olivier, ici ce sont les versions anglaises.
Here we only have the English version, but we also need the French. And I'll
read the motion now, Mr. Chair.
Oh yeah, no, sorry. You don't have a copy yet? No. Okay, sorry. We will make sure copies are properly distributed in English and French. On va assurer que la version française.
We'll make sure that the French and the English versions are also distributed.
If I may, just while they're being distributed.
Absolutely, Mr. Collins.
Thank you for your introduction. And just on this small point, I think you raised some concern that the motion that was brought by ourselves and the Conservatives was brought without consultation. I think the same concern could be brought to the motion that we're about to read now. So if we're being consistent in terms of what we're doing here today, I'd just like to understand how you imagine going through this, because I believe order, and I'll refer through you to the clerk, the order of precedence in which the motions were submitted The committee is it not obligated to deal with the motion as it first gave notice? Because we're only getting this motion seconds ago as Mr. Boissonnault has introduced it with no time to reference it. We have a motion that has been tabled by the opposition that is also due consideration and shouldn't be replaced.
So thank you very much, Mr. Collin. My understanding is that whoever's recognized first can put forward the motion, that the request was to have a meeting which we have convened. The goal here was not to be in any way non-consensual. If we get to talking about the motion, the goal was to actually be consensual and try to work together to come up with the appropriate timetable and witness list and everything else. So the motion is appropriately put forward. Est-ce que la version française a été distribuée?
Has the French version been distributed? Only in French? Are no English versions that have been distributed?
To read it into the record, and then we'll be happy to entertain any questions at all, either on procedure or the substance of the motion and debate. And then, of course, as the opposition knows, if this motion is amended or refused, then that other motion can be put forward 100%. It's not out of order in any way. Mr. Collin, did you?
I just wanted to be put on the speaker's list for once Mr. Boissonnault had read the motion.
Of course. I have 3 people now. I have 4 people. Sorry. I have 4 people now. We will get everybody on the speakers list. So I have Mr. Collin, then Mr. Fraser, then Ms. Raitt, then Mr. Cooper. Yeah, no, the first is Mr. Boissonnault still has the floor to deliver the motion.
Thank you, Mr. Chair. That the Justice and Human Rights Committee hold meetings to examine remediation agreements, the Shawcross Doctrine, and the discussions between the Office of the Attorney General and government colleagues, and that the witness list include, but not be limited to, Minister of Justice and Attorney General Honorable David Lametti, Deputy Minister of Justice and Deputy Attorney General Nathalie Drouin, Clerk of the Privy Council Michael Warnick, and that the committee meet in camera on Tuesday, February 19th, 2019, at a time set by the chair to discuss obtaining a legal opinion on the sub judice rule, potential additional witnesses, and a timeline for the meetings. Merci, Monsieur le Président.
Merci, Monsieur.
Thank you, Mr. Chairman, and thank you, Mr. Boissonnault.
Thank you, Chair. Mr. Boissonnault, I thank as well. Just in small passing, I note the absence of Ms. Jody Wilson-Raybould in your witness list. That clearly would be somebody Canadians would be very keen to hear about, as she has been obviously a central figure to us. Her omission in your list is more than interesting to me, and I think there's some other people, as if I'm comparing the 2 motions, because I think that's fair to do. This is your response, I essentially assume, to what the Conservatives put forward. There are a number of key people that may be absent. Chair, if I may, as I've expressed to you, I found the current Attorney General's comments just this past weekend in the public in the media, without having spoken to Ms. Wilson-Raybould, as he admitted, or spoken to anybody really about this, only hearing the Prime Minister's public comments, has decided that there was nothing to investigate here. That's troubling for me as Canada's chief prosecutor. His remarkable lack of curiosity over a potential obstruction of justice occurring in the office of the Prime Minister, for him to essentially pass judgment. And I think, I, with great respect to my Liberal colleagues on this committee, I could not help but see how his comments were an attempt not to influence what happened at this committee, suggesting that he saw no grounds for investigation before we'd even met and had our conversation, I found was incredibly unhelpful and inappropriate. What we are talking about does, I think, I hope all my colleagues would agree, the matter at hand here goes to the very heart of our democracy. How it is that the halls of power work and how they interact, if they do and when they do, with the independent judiciary that we pride ourselves on as Canadians. I think this case, I think Mr. Norman's case, Vice Admiral Norman's case, and others have started to call into question the commitment from this government to the independence of that judiciary. Now, to Mr. Boissonnault's motion and to his argument, I think in your preamble you suggested that the Prime Minister's public comments, or maybe perhaps it was you, Chair, the public comments from the Prime Minister were solid and verifiable. My trouble with that is that the central proof the Prime Minister of Canada used as to why there was nothing to see here evaporated within 24 hours. That when asked directly by a member of the media, was there any undue influence put on Ms. Wilson-Raybould, his comment, well, was her continued presence in cabinet speaks for itself. That was the proof offered up. I would assume then that the opposite is also true, that her decision to resign from cabinet is also telling us to what is occurring in front of us. All I would say, I'm not satisfied with the motion as it's written. I think there may be a combination, perhaps. I think understanding, and I'll try to end here, Chair. I think an understanding of sub judice rules that committees have dealt with before, by the way, at other committees, when there's been something before the court that the committee wants to investigate. How do we make sure that we don't negatively affect the court process? I think that's important. I think understanding solicitor-client privilege is also important. Yet, I'm not interested, and I doubt Mr. Rankin, who I'm doing a poor job filling in for today, would be interested in some 7-month wandering expedition into the deep bowels of Canadian law and jurisprudence to understand minutiae that isn't helpful to us. We need to get to the substance of the matter because that's what Canadians expected of us. And I wholly concur the quality of the work done by this committee, its collegiality. And I'll end with this, and with all due respect to my Conservative colleagues, I thought the use of social media directed at my Liberal colleagues across the way with phone numbers and emails was inappropriate. I understand that there has been a fair amount of hate expressed towards some of my Liberal friends. If there's any attempt to do right by Canadians here, we need to be able to rise as best we can above the partisan interests that each of us bring to the table, to acknowledge them and yet stand above them. What we see here, the case that we have in front of us, is one of the most troubling I've seen in my years of politics. The allegations in the Globe and Mail were serious, and the fallout that has occurred since then has only increased my worry, and I think I reflect the worry of many Canadians, wondering what exactly is happening and why has this been allowed to happen. So I think this motion, if it were to be considered, needs amendment, and perhaps there's a combination between the two that committee members would find acceptable.
Thank you very much, Mr. Cullen. The motion is on the table, so it's being debated. Just in response to your question about the witnesses, we've included the list of people who we know will attend, that they are prepared to attend. Nobody has spoken to Ms. Wilson-Raybould in any way. But what we tried to do, and of course I'm monopolizing time, but we tried to say on Tuesday, we will all get together and talk about timetable and witnesses. And I'm entire agreement with Mr. Cullen. There's absolutely no need to have multiple meetings to establish legal frameworks, but I think it would be helpful to have one meeting at least to understand the Shawcross Doctrine and from people who really understand it very well.
So just to confirm what you said, Chair, that these three witnesses that you've put forward, the Clerk of the Privy Council, the Deputy Minister of Justice and Deputy Attorney General, and the current Minister of Justice and Attorney General have all agreed so
This
far
is
to
my
appear?
understanding at this time.
Okay, thank you.
Thank you very much, Mr. Cullen. I was wrong before when I said Mr. Fraser. Ms. Raid I saw first, and she should be recognized anyways because I haven't recognized the opposition yet. So, Ms. Raid.
Thank you very much, Mr. Chair, and I appreciate the comments of Mr. Cullen, and of course I appreciate the comments of Mr. Boissonnault. I have prepared comments that I'd already prepared for today, which I will read, but before that, Mr. Chair, I did want to make a few points. First of all, in your preamble opening up today, you indicated that Canadians are rightly concerned, and I agree, and that we do want to make sure that Canadians understand, but you've also said in the past, Mr. Chair, that you believe the Prime Minister, and you believe that you don't need to speak to the Prime Minister personally, because I don't believe you have, in order to judge whether or not what the Prime Minister says is the accurate description of what is exactly happening. And what is happening is the contention that allegations have been made that the Prime Minister's office has politically interfered with the office of the Attorney General. That is why we're here today. Mr. Boissonnault, in opening up today, said that there is a clear concern with Canadians. I agree. But then he also went on to say that the Prime Minister has been clear, and I fundamentally disagree with that. The Prime Minister has not been clear. That is exactly why we're sitting here today. The Justice Committee does have a responsibility, but it's to get to the bottom of what's going on, not to do what Mr. Boissonnault said, which is to assure Canadians that what the government is doing is okay. That is not our job here. Our job is to ask tough questions of witnesses to determine whether or not there has been some kind of wrongdoing. And that's exactly by which the spirit we approach this meeting today. I agree we need to shine a light, as Mr. Boissonnault said. And I agree that we don't want to impact court proceedings, but I don't see how having a conversation about the interior workings of the government vis-a-vis the Attorney General's office is going to have an impact, because it's all about political interference and whether or not there was inappropriate political interference put on the Attorney General. I also appreciate, Mr. Chair, that you fully understood and knew that we were bringing the motion together today. You'd have to live under a rock not to know that we were going to be doing that. And I also know, because you said it today, that you recognized Mr. Boissonneau first. It is your purview, but I think it's important to understand that despite the fact you knew we were coming forward with the motion, you decided to recognize the Liberal member before in order to make sure that we were not going to be able to put forward our motion. And that is noted for me. And as I said before, I do believe, Mr. Chair, that having read your comments to the press in the past number of days, that I would have to question whether or not you have bias in the issue, since you've already said that you believe the Prime Minister and the Prime Minister's office in this matter. And that's what we're here to get to the bottom of. So with that, I would like to outline, of course, that this is a very important issue, that media reports have revealed very troubling allegations with respect to possible interference by the Prime Minister's office in the criminal prosecution of SNC-Lavalin, and further, that instead of fulfilling his duty to providing clarity to Canadians and living up to his lofty campaign rhetoric around openness and transparency, the Prime Minister has obfuscated and he has dodged. First, his story was that the media report was false. Then, when the position became untenable, his story changed. He admitted that while there were conversations about how Jody Wilson-Raybould was difficult to get along with and only in it for herself, and I cannot tell you that as a female leader in this country, from business and politics, that standard gendered criticisms of female leaders is absolutely unacceptable, and I'm so disappointed that the Prime Minister and nobody from his office came out to defend these, came out to say that these were wrong and nobody should be making those comments. I take Mr. Cullen's point, his point of view that we shouldn't have gone and made the social media comments that we did. But where is anybody on this side saying that those comments about Jody Wilson-Raybould that came from within the PMO are acceptable in this land? We know that's not acceptable. We know that they shouldn't have been said, and we know what they were meant to say. And then it changed further to become about the meetings that the Prime Minister had last fall, to tell at the time the Attorney General that decisions related to the Public Prosecution Service were hers alone. The Prime Minister even went so far as to say that Jody Wilson-Raybould's presence in the Cabinet should actually speak for itself. And then yesterday, it all changed again, when Ms. Wilson-Raybould resigned from Cabinet. In his press conference last night, the Prime Minister changed his story again, essentially this time accusing Ms. Wilson-Raybould of turning a blind eye to misconduct in his own office. Now, it's been an extraordinary evolution of the Prime Minister's story, but what it does show is that this is not a government that we can show Canadians is under control. This is a government that we can show Canadians is in total chaos. And it raises critical questions of ethics and conduct from the highest ranking staff in his office. What we know, thanks to the reports from the Globe and Mail, that pressure was applied to the Attorney General to overrule the Director of Public Prosecutions and advocate for a deferred prosecution agreement for SNC-Lavalin. What form did this pressure take? We need to know when and how. Did Katie Telford speak to Jody Wilson-Raybould about SNC-Lavalin? We need to know when and how often did Gerald Butts speak to Jody Wilson-Raybould about SNC-Lavalin? We need to know when and how often did Matthew Bouchard speak to Jody Wilson-Raybould about SNC-Lavalin? We do know that he met with SNC-Lavalin a frequent number of times. We need to know when and how often did Elder Marquez speak to Jody Wilson-Raybould about SNC-Lavalin, and we need to know when and how often did the clerk of the Privy Council, Michael Wernick, speak to Jody Wilson-Raybould about SNC-Lavalin. Further, we have learned from court proceedings that there has been a high degree of cooperation between the Privy Council office and the Public Prosecution Service in the matter of Vice Admiral Mark Norman. The judge even said in open court, so much for the independence of the PPSC. That is a grave statement to be made by somebody holding the esteemed position of judge in this country, and that is something that parliamentarians should take note of and do absolutely everything we can to get to the bottom of what's happening. Canadians deserve to hear from the Director of Public Prosecutions as to what her standard practices are. How often has she spoken with PCO about ongoing matters, including SNC-Lavalin? And did PCO act to launder the communications from the PMO? Did the Director of Public Prosecutions speak to PMO directly? If so, when and to whom? Canadians also deserve to hear from Jessica Prince. Ms. Prince is an accomplished attorney who has been serving as the Chief of Staff to Minister Wilson-Raybould, as she then was. And as a former minister, I know that there's a frequent and significant contact between what's known as the centre, in other words, the PMO and PCO, and the minister's Chief of Staff. Ms. Prince can tell us if anyone pressured her into taking any action or relaying directions for action to the minister. And if such pressure was applied, who did it, when did it happen, and what form did it take? And to really get to the crux of the matter, we need to hear from former Minister Wilson Raybould herself, because she can provide clarity on this matter as the primary person involved. And I would also call on Prime Minister Trudeau to waive any notion of solicitor-client privilege so that there can be full transparency and accountability. You know, Mr. Chair, you said in the last few days that you're concerned about the partisanship of the committee and that you were not going to support our motion because it was too partisan. But the reality is the truth is not a partisan issue. Canadians do expect the truth, and we have the power here to make sure that they get it. And I sincerely hope all members of this committee will recognize that. I'm not satisfied with the motion either, as Mr. Cullen has said, but I look forward to hearing from the other members as to what they have to say, and I thank you for your time.
Thank you, Ms. Raitt. Mr. Fraser. And then Ms. Cooper Khalid.
Thank you, Mr. Chair. Good afternoon, everybody. Obviously, I take exception to some of the things that have been outlined already, but I think we are here today to try to move forward on this matter. The motion that has been advanced by Mr. Boissonnault, I believe, is a reasonable motion, and I will be supporting it. It is designed to reassure Canadians and to show how Parliament can work and do good work at this committee, which we have shown time and time again on very important issues for Canadians. The decorum with which we conduct ourselves at committees such as this Justice Committee will be noticed by Canadians, and I think that we can reflect the best of ourselves if we work together in a way that seeks to reassure Canadians and to find out what has occurred in this situation. I do think it's important that the motion that has been submitted by Mr. Boissonnault mentioned that there is potentially an issue regarding the sub judice rule, and I think that it is incumbent on our committee, as Mr. Cullen said, to examine possibly that issue to ensure that there is fairness to a matter currently before the courts, and I do think that is an important feature of this motion. I also notice that, or believe that, examining the Shawcross Doctrine, which actually lays out the standard with which an Attorney General can interact with others in committee, cabinet colleagues and others, is an important way to show Canadians what that standard is and reassure them that there are principles surrounding this and that discussions surrounding the Attorney General with matters currently being prosecuted is adequate and is okay, but that we need to understand what that doctrine says so that Canadians can be reassured of what the proper standard is. So those are my submissions, Mr. Chair. I thank you very much for convening the meeting. I agree with Mr. Boissonnault and will be supporting his motion unamended. Thank you.
Thank you very much. Mr. Cooper.
Well, thank you very much, Mr. Chair, and let me first of all acknowledge your comments at the start of this meeting that we as a Justice Committee have worked well together. I've had the privilege of serving on this committee for the past 3.5 years, and I can say that while we've had policy disagreements, that we have worked well when we have studied issues each and every time. In fact, we've come back with unanimous reports. That's rather unusual, but I think it does speak to the fact that the members of this committee have integrity and have put aside partisan politics. So let me acknowledge that. But let me also say that this is not a partisan issue, in as much as what this issue relates to goes to the heart of the rule of law. When we're talking about interference in an independent criminal prosecution, an attempt to potentially interfere with the independence of the Public Prosecutor Service of Canada, the PPSC. And while I agree with Mr. Fraser that Canadians deserve to be reassured, let me say that this motion put forward by Liberal members, Mr. Boissonnault, does little to reassure Canadians. For a Prime Minister who has talked about sunshine being the best disinfectant, I would have thought that the members on this committee, the Liberal members of whom I respect, would have been eager to get on with sunshine so that we could hear as quickly as possible from witnesses who may be involved in political interference. The fact is that you asked, Mr. Chair, how did we come to this point of an emergency meeting? We came here because when the Globe story broke, the most basic questions asked of this government related to this matter were not answered. Instead, we received non-answers. The Prime Minister's story, as Ms. Wright outlined, has changed. He, first of all, denied the story completely. He then shifted to speaking about whether or not there had been direction. He then, just 2 days ago, said that the fact that Jody Wilson-Raybould remains in cabinet speaks for itself. We know that the first thing that Minister Wilson-Raybould did in response was to resign from cabinet. Now, this motion provides no assurance that we'll get answers anytime soon. It contemplates a long, drawn-out process that I believe is intended to cover up, to further cover up this serious issue at hand. It's rather interesting that so many of the key players are omitted from this motion, including the Prime Minister's Quebec advisor, as well as Gerald Butts, who met with SNC-Lavalin officials on matters that pertain to justice and legal matters. I don't think it's a coincidence that those individuals are omitted from this list. I regret to say that the only conclusion I can draw is that there isn't an interest to get to the bottom of this matter. And I'm troubled by the fact that this motion would provide for an in-camera meeting to discuss a potential list of witnesses. So much for openness, so much for transparency, so much for providing the opportunity for Canadians to hear the arguments about why certain individuals should be called. If members of this committee object to Mr. Butts coming before this committee, they should make their case, and they should make it publicly, not behind closed doors. The fact is, Mr. Chair, and I do think it's important that we talk a little bit about some of the facts in this situation, because I've been disappointed that members of this government have said, well, these are just general allegations. Let's talk about what these allegations relate to. They are supported by a number of key facts, starting with in October of 2015, when SNC-Lavalin indicated that they wished to enter into a deferred prosecution agreement. The only problem that SNC-Lavalin had was that there was no provision in the criminal code to allow for a deferred prosecution agreement. So what did SNC-Lavalin do? Well, they proceeded to meet with officials at the highest levels of the PMO dozens and dozens and dozens of times. 14 meetings on legal and law enforcement issues. This from an engineering firm. What a coincidence. What a further coincidence it was when the government snuck into the Budget Implementation Act amendments, substantive amendments to the Criminal Code relating to deferred prosecution agreements. No consultation held by Justice Canada, no meaningful consultation on the part of this committee. It just was snuck in, hoping that Canadians wouldn't know the difference. Then we know that in October of this year, the Director of Public Prosecution Service of Canada announced that they would not proceed to negotiate a deferred prosecution agreement with SNC Lavalin. Immediately following that, the Attorney General, the former Attorney General, Jody Wilson-Raybould, was fired at the first opportunity available to the Prime Minister. And then, of course, her comments about speaking truth to power, and then, of course, her decision to resign from cabinet altogether. So there are a lot of facts that underline these serious allegations, and it speaks to the need for transparency and openness, something that this motion utterly fails to do. It needs to be defeated out of hand.
Thank you very much. We next have Ms. Khaled.
Thank you, Chair, and I welcome the new members to the Justice Committee as we talk about this. And I must say that I have a lot of issue with the speculation that Mr. Cooper has put forward here in his remarks. Mr. Chair, I really appreciate that you started off by assuring everybody how nonpartisan and how cordial we have been able to act here as a committee. We are independent, have not been influenced in any way in our decision in what we are deliberating here today. And I remind Mr. Cooper that the words of the motion do not limit the witness list to what is here proposed. These are, as the chair said, the witnesses that have agreed to come forward. They're not the witnesses it's not a complete list of witnesses. The way that we've really conducted our committee over the past number of years has been to have discussions. In-camera discussions are very normal in how we come up with our witness lists. So I really encourage my friends on the opposite to not make political hay out of this. Putting up our phone numbers on the Liberal benches on their platforms and on social media is really not the way to go. I think that this amounts to bullying. We have been and continue to be a very independent committee, and I think that the discussion today is really as independent as it gets. I stand by the integrity of this committee. I know in the past we have had many robust discussions about how we conduct ourselves, about the various bills and studies that have passed through this committee, and we've done well in how we've been able to have those discussions and to understand exactly what it is that we're doing for Canadians. Absolutely, Canadians have a right to know how their government functions. Absolutely, we run on a platform, and we, I as a member of firm Mississauga and Mills, absolutely agree that the government should be open and transparent, and we have been. And I think that the motion before us today really speaks to how open and transparent we are. We're willing to look into this. We're willing to look into what the standards are between the relationships between the Attorney General and the Prime Minister's office and our colleagues in general. And as we delve into this, I think that we'll have a clear picture that Canadians really deserve to know what the nature of that relationship is. And we as a committee have that duty and obligation, and I stand by my colleagues in making sure that Canadians have that right to know, and will ensure that they do have that. At the same time, I don't appreciate the political posturing that is going on here, the hate that is being created out of nothing, and would look forward to speaking to what our permanent members of the Justice Committee have to say about witnesses, and how we can come together on a consensus as to how we move forward with this study, and provide the clarification that Canadians deserve on this issue. So I am very happy to support the motion that is before us today, and I look forward to really providing that clarification.
Thank you very much, Ms. Khalid. I would just also point out as a factual matter, I don't recall one time over the last 3 years that we've agreed on our list of witnesses in anything but an in-camera meeting. That is the normal course of this committee. Mr. Collin.
Yeah, and that may be true. This is obviously a unique situation, I think you'd agree, Chair. This isn't your typical committee study, and I think even calling it a study, this is clearly an investigation. I was listening intently to Ms. Khalid's point. I think she may want to reconsider the expression that making a lot of hay created out of nothing. Your colleagues have expressed, the chair of this committee, certainly many legal experts. The former Liberal Attorney General in Ontario suggested that charges have been brought against Canadians for obstruction of justice with much less evidence than we already have in place today. I think the experience that Ms. Wilson-Raybould has gone through in the last week is not nothing. I think the experience of watching a Prime Minister stand up in front of Canadians and say, there's nothing to see here, and the proof that I have is that Jody Wilson-Raybould is still in Cabinet. And then less than 24 hours later, his proof evaporates, and Ms. Wilson-Raybould is not only left Cabinet, but then has the spectacle of the Prime Minister referring to her in the first person while male colleagues in the legal titles. I agree wholeheartedly with my colleague, Ms. Raitt. I thought that spectacle was unbecoming of a Prime Minister, frankly, towards a woman who has held herself with some great integrity, and I think the comments of Minister Philpott would do much better on this government than those by the Prime Minister himself. Now, to this, we've actually made some suggestions that I've not heard any of my Liberal colleagues respond to. They just say that they're going to support this, and I'm sure my friends would like to reassure Canadians. We can't reassure Canadians because we don't know what happened here yet. One would to suggest that we can reassure them with this motion is to suggest that there's nothing to find. And I would submit humbly that the last week has told us, less than a week, has told us that there's clearly something here. There is the most grave allegations, as the chair himself and others have commented on. The Shawcross, we keep talking about this principle. I think it would be helpful for those trying to follow along as to what we're talking about. It is not the Shawshank principle, as some have referred to it on Twitter, once again confirming that particular site isn't always great for information. And it's about the role of the Attorney General, in particular the independents. And I think it bears some understanding as to why I'm going to make a suggestion that we include more witnesses than the Liberals have put forward so far. And I would make a second suggestion as to the limitation of how deep we go into the weeds on some of these other legal principles. But the Shawcross principle on Attorney General independence states that Cabinet consultation is, quote, confined to informing him or her of a particular considerations which might affect his or her own decision, and does not consist and must not consist in telling him what that decision or her ought to be. The responsibility for the eventual decision rests with the Attorney General, and he or she is not to be put and is not put under pressure by his or her colleagues in that matter. Right? This is what we're talking about. This is the fundamental thing. I understand that some committees often don't include all of their witnesses, but we've started. We've started naming some witnesses that Liberals, through your words, Mr. Chair, have reached out to the first three that you've mentioned here, which are also three that appeared on the Conservative list. We have to include an invitation for Ms. Wilson-Raybould to speak. It baffles me that isn't the most obvious thing in this entire conversation. Now, whether she chooses to or not, we can't subpoena her, of course, and nor would we. She has the privilege that's extended to all of us to not appear, and she is also getting the highest quality advice on that. Also, in those allegations that have been brought forward, the Principal Secretary to the Prime Minister seems to be also an obvious witness that must testify. So true, the senior advisor to the Prime Minister, Monsieur Bouchard. This might be unusual, Chair. It might not be the precedence that the committee normally takes. This is unusual, this entire thing, and this is not of the opposition's doing. This is a story that first came to us through Mr. Feist's reporting in the Globe and Mail. And as is often the case of, I don't want to call it scandal yet because that infers guilt and we're not there yet. But what is often the case I've experienced is it's not just the act itself, it's the attempt to cover up the act that Canadians so often find infuriating in our politics. So if the committee is sincere to reassure Canadians that the system is working, this system is working, then respond to some of the suggestions that we've made as oppositions. If collegiality and consensus-based decision-making is at interest here, we've made some suggestions. So I've put 3 extra witnesses forward. I haven't heard my Liberal colleagues respond to that. And secondly, if we are going to look at sub judice, if we are going to look at this Shawcross principle, that we commit a day or a meeting of your discretion that the committee agrees to look at those. I think my point is to put some time limitation on that. One could spend one entire legal career studying Shawcross if they wanted, and that's not helpful to anybody, and it's not helpful to Canadians in understanding that. I think if we are seeking to actually reassure Canadians, we can't reassure them on the outcome. This isn't making hay out of nothing. That's a mischaracterization of everything that we've seen here so far. I respect my colleagues. You're under a lot of pressure. No other than the Attorney General of Canada went on television this weekend and told you there's nothing to see here. That's unfortunate. I sympathize with the pressure that you're under. As you've also said, your duty is to Canadians, not to the Prime Minister's office, nor to the Attorney General. We can come and collaborate on this. I think inviting Ms. Wilson-Raybould, I think inviting the Principal Secretary, as well as at least the Senior Advisor to the Prime Minister, Mr. Bouchard. It seems obvious to everybody looking at this case. Why it wouldn't be obvious to all members on this committee would be perplexing to me, and I think would invite the allegations of an attempt to limit and cover up what is actually happening here, which my Liberal colleagues haven't said in so many words, but I'm sure that is an interest that you share with us, is that Canadians do feel reassured that we're getting at this, understanding all the limitations that we're faced with so many trials taking place. The central argument, though, is that a very well-connected international company was able to lobby and successfully secure a change to our criminal code. It was placed into the very last pages of a 535-page omnibus bill. There are now allegations that that measure was then pushed upon the former Attorney General, and that perhaps when she resisted, she was fired. And then when the Prime Minister said, we're all on the same page here, and the evidence that we are is that she's still in my cabinet, the next day she quit. If anyone wants to say that's not concerning to them, boy, oh boy, you're living in another reality than I occupy. I think we owe it to Canadians to do this. Consider the 3 extra witnesses that have been proposed, and consider the suggestion that the limitation on the study of these other legal principles is also put in place, that we don't go on some fishing expedition.
I understand. Are you putting that forward as a formal amendment right now, or
That'll
are
be
you
a
putting it
formal
forward
amendment.
for discussion?
Let's put that as a formal amendment, Chair, because I
Well,
think because folks aren't commenting on the suggestion from the opposition. So what we've heard so far is the Liberals put forward a motion. The Conservatives have said we're going to reject it out of hand. I'm suggesting is there a potential to combine the key elements, because the core differences are there's not a limitation on the study, and that the witness list that is prescribed by the Liberal motion is very, very limited.
Can I make a suggestion, Mr. Collin? Because
Yep.
we have other people who, I guess, haven't intervened yet. Can I come back to your
You betcha.
amendment when we get to the end of this, like the people who have asked to speak here? We will then come back and put your amendment as the next item, and while you have the time, maybe you want to draft it.
Very sage counsel.
Perfect. So we now have Mr. Poilievre.
Thank you very much, Mr. Chair. Now, the members across the way keep talking about innuendo. So let's go back to the agreed upon facts and list them in chronological order. Fact: the Prime Minister slipped into an omnibus budget an amendment to the criminal code allowing large-scale corporate criminals to escape conviction and trial by signing a deal. Fact: that legislation was not introduced by the Justice Minister, even though it amended the criminal code, which is the purview of that minister. Fact, this committee had no role in studying that legislation. It went to the Finance Committee. Something that should concern you, Mr. Chair, and all members of this committee. Fact, after that legislation became law, the Director of Public Prosecutions decided not to offer a deal to SNC-Lavalin, which is charged with over $100 million of bribery and fraud. Fact, according to the lobbyist registry, the company changed its tune away from a legal approach to a political one, going to the PMO to seek political support to allow for a special side deal that would remove the possibility of conviction or trial for this $100 million worth of corruption. Fact, 14 meetings happened in the Prime Minister's office, including with PMO boss Gerald Butts. Fact, Mr. Butts in December and the Prime Minister at another occasion spoke about such a special deal with the Minister of Justice and Attorney General. And fact, not so long after that, the Prime Minister fired the Attorney General and moved her to another portfolio. Apparently, the conversations with her didn't go so well. Now, they say there's no political pressure. Do something, or you might lose your job. But hey, no pressure. Please, make your own decision. Now, since that time, the Prime Minister went out publicly and claimed that he had assurances from his former Attorney General that he had told her that the decision was entirely hers. After he made that public declaration, something caused her to resign, apparently no longer able to remain part of the Trudeau cabinet. So he attacked her. He directly attacked her, saying it was her job to stop wrongdoing from happening in his office. But what was most despicable and cowardly about this attack is that he was attacking someone who is legally incapable of defending herself. She believes she's subject to solicitor-client privilege. In other words, she can't fight back. She can't speak. Now, there's one person who could allow her to speak. Of course, that is the Prime Minister. You would think that a man who attacks someone in public would want to allow that person to respond. But so far, he has used his power of privilege to silence her. And the members across the way talk about bullying. Now, it's time that we let her speak. And isn't it interesting that this motion that the government puts forward does not include her name?
The government
does
did not put forward the motion, Mr. Poilievre. The motion came forward from people who are Liberal members of this committee, and I have to correct you on that. I would have corrected you on multiple other points, but I'm trying to restrain myself.
Sure. You actually said we put it forward, so I presume that you're speaking with the rest of the we over there. But
Not the government. There are Liberal MPs on the committee.
The reality is,
but you haven't been to the committee before.
The reality is, I appreciate you're getting very defensive, Mr. Chair. Yeah. But I appreciate you're getting very defensive, and I don't blame you. Because frankly, sir.
Along very well, sir. Your interventions are at this point just a little much. I will restrain myself at this point.
I welcome that restraint. Mr. Speaker, Mr. Chair, the reality is that this motion excludes the key actors. It prevents them from speaking. It does not include former Attorney General Jody Wilson-Raybould. It does not include Gerald Butts. It does not include Katie Telford. And the single meeting that it allows, or that it identifies, is in camera. And for those listeners who don't know what that means, it means in secret. No media, no transcripts, no public information, nothing. Total silence. And for what? The promise that we might be allowed to have a legal symposium about some theoretical principles that, while they might be important to the overall case, do not speak to the facts in this particular situation. And that is what we are here to discuss. We're not randomly picking one of the many thousands of legal principles that have been debated in law schools by scholars for many years. We are talking about a specific case. And for us to know the answer to that case, we need to have the key players. And so I'm calling on the government to amend its motion to include all of the witnesses that Conservatives have put forward in order that all the truth and all the facts become known by Canadians. And if the government has nothing to hide, then it will allow these witnesses to be added and for examination of their testimony to proceed without any further delay. Thank you very much.
We now have Mr. Boissonnault.
Well, thanks, Mr. Chair. I think it's important to remind colleagues and Canadians that the Ethics Commissioner is undertaking a probe into this matter, and that the role of the Justice Committee is not an investigative body. I think today's testimony or comments from particularly the Conservative opposition demonstrate that, at best, committees of the House of Commons are political theater that can occasionally achieve good studies, and that we don't have the tools, we don't have the budget, we don't have the mechanisms to go through the fishing expedition and the kind of witch hunt that the Conservatives would like to see. Let's be clear. The Ethics Commissioner is looking at these issues, and that is the impartial body of the Parliament of Canada, empowered to look into these matters. Our job is to take a look at issues that will shine a light on exactly what is appropriate behavior. And quite frankly, it's completely legitimate for the Attorney General's office to have conversations with government colleagues about legal matters. And the Shawcross Doctrine, as Mr. Cullen quite rightly read out, provides very clear parameters for that. And let's understand what remediation agreements are. And I can state that the reason we had a change to the criminal code to deal with remediation agreements is to harmonize with our trading partners. The other side is engaging in rank speculation as to why we would make a change to our laws when the United States has had remediation agreements, which there are called deferred prosecution agreements, since 1999. The United Kingdom has had deferred prosecution agreements since 2014. Australia is studying deferred prosecution agreements now. This is a normal course of business with trading partners around the world. And for the other side to engage in some sort of rank amateur speculation that somehow one corporation is going to move the government of Canada to change our laws is specious. Quite frankly, it's not parliamentarian. And our job here is to help Canadians understand remediation agreements, to take a look at the Shawcross Doctrine, and to have these three people on this witness list come. And to my colleagues across the way, it is completely legitimate for this committee to have a conversation about the witness list. And to Mr. Cullen's point, we are going to have meetings, but we want to discuss next week the number of meetings and the witnesses that we would have come forward. And quite frankly, to your point about Ms. Wilson-Raybould, she can't speak. My colleagues here know that she can't speak about her time as being the former Attorney General. And she has invoked solicitor-client privilege, and she has one of the best lawyers in the land advising her. So to have her come before this committee would be to invite her to speak about things that she simply cannot talk about. And so I think it's important for Canadians to understand that as well.
Thank you. Mr. Paulus.
Mr. Paulus. Thank you very much, Mr. Chairman. First, I'd just like to point out that my colleague said that we are engaged in a witch hunt, but I would like to say that truth rises above any partisanship, and therefore there's no witch hunt on our part. And this story actually came out in the Globe and Mail, and since then, other things have happened over the course of the days. Now, the motion from the Liberals suggests 3 witnesses. I'd like to know who suggested that they come and testify. Now, I'd also like to point out that we're in a country under the rule of law. This is a very, very worrisome situation for all Canadians and all those who are listening to us. This has to do with influence from the PMO on the former Attorney General. Now, we had a motion that was ready, that was brought forward to the committee, and then through various procedures, the Liberals have come forward with a motion that we're now discussing. But in fact, what we're getting is sort of a class, a law class here. You know, I'd like to thank my NDP member who explained what the Shawcross Doctrine is, but we don't actually need a course in legal affairs. I think that we're the Justice Committee, and what we need to do is get to the heart of the issue. And we need to go through proper procedure. But what the Liberals are doing right now is just proof that they're engaged in a cover-up themselves. And what we want to do on our side is shed light on a situation that was actually disclosed by the Globe and Mail and which has just been evolving and developing over the course of the past few days. Now, there is a motion brought forward by the Conservatives, supported by the NDP, and I think that's what we should be discussing and voting on in the interests of all Canadians. Thank you very much. And just so that everybody understands, there are more Conservatives here than normal because there were 2 invited members who have a right to be here and have a right to speak, but it's not that there are 5 Conservative members of the committee. There are actually 3. But they have the right to speak, and we'll also give the floor to Mr. Fortin if he wishes to speak. Ms. Khalid.
Thank you, Chair. And I just want to clarify to Mr. Cullen's point. I really appreciate his comments, and I do want to clarify that when I said nothing, I did mean nothing substantiated. You know, we are basing all of this on recent events, and I'm sure that events will change. And quite honestly, we've had a really good interaction with all colleagues on this committee, and I look forward to discussing the complete membership, the complete witness list with the permanent members of the committee. That includes Murray Rankin and Dave McKenzie and Mr. Barrett, as you're here today, and Mr. Cooper. I think that'll be a very healthy exercise in democracy, and Canadians do need to know what the nature of that relationship is that this motion is addressing. I hope that, or I can understand that the Conservatives must have gotten their sound bites out today, and that's really what it seems like their objective is in understanding why they're here. I mean, the objective of this committee is to get to a conclusion as to what Canadians are looking for, which is a clarification and an understanding as to the nature of the relationship between these 2 bodies. As I said before, the list that is of witnesses that is proposed in the motion is not a complete list. It is the motion clearly says, and that witnesses list include but not limited to. And I think that my colleagues across the way need to really understand and appreciate that. We're hoping that we can have a more robust discussion, as is regular committee business, in camera to discuss the full list of witnesses for this proposed study. And I do want to clarify for Mr. Cullen that the role of our committee is not investigative. We really don't have the tools, or it's really not the scope of what our committee does. We study issues that are important to Canadians. We study bills and propose and really study the impact of those bills and legislation to Canadians. But we are not here to look into what basically the Ethics Commissioner has now undertaken to do. We're not here to replace what the Ethics Commissioner will do. We are here to provide an understanding and a clarification to Canadians as to what the nature of the role is between the Attorney General and the Prime Minister's office and cabinet colleagues in general. And really, I hope that my colleagues across the way will support this motion, which is really a non-partisan version of the motion that the Conservatives have proposed. It is really the bare bones and substance of what everybody around the table and all of Canada really wants, is that clarification conversation as to the role between how government functions and how decisions are made.
So much. The next person on the list is Mr. Cooper.
Thank you, Mr. Chair. I have a few comments, but I do have a question picking up on the point that Mr. Paul Hoos raised, which is in respect of the motion that has been put forward by Mr. Boissonnault. We have 3 individuals on the list. Of course, a number of the key actors coincidentally excluded. I was wondering who called these witnesses in advance. Was it you, Mr. Boissonnault? Was it you, Mr. Chair? Who called them?
Who called them? My understanding was that Mr. Boissonnault. Do you have that answer?
Well, I do have an answer.
My
colleagues in government reached out to these people,
Yeah.
and they indicated that they will be able to.
Is that PMO?
No.
It is not PMO.
No.
Have they called Mr. Butts?
Again, we have not, and we purposely, just to be clear,
Did Mr. Butts refuse?
we have purposely, the members of this committee, because, indeed, of the enormous allegations that were coming that you guys were putting out that PMO would somehow kibosh this, would tell Liberals on the committee how to act. We deliberately, very, very deliberately have not in any way contacted anybody in PMO, which is why you would never see Mr. Butts' name there. We have not done that. We were, it's funny, you guys on social media have gone all over saying the Liberals on the committee are going to kill this.
Mr. Chair, I asked a very straightforward question, which was who called these 3 witnesses? There was no clear answer provided. I asked of the other individuals on the list of our motion, were they contacted too? I haven't received an answer to that, and I simply ask it again. It's a straightforward question.
So my understanding is nobody else has yet been contacted.
Just those 3 individuals.
That is my
Very
understanding.
interesting. Very interesting that the key actors, Mr. Butts, Ms. Telford, and others were not contacted yet. It says a little bit about maybe where the Liberal members on this committee want to go. And I've got to say, in response to Mr. Boissonnault, before I came here today, I was really hopeful, given the work that we've done as a committee together, that Liberal members on this committee would be as concerned as I and my Conservative colleagues are, as well as New Democrats, Mr. Rankin, I think most Canadians, about the very serious allegations which, if proven true, speak to corruption at the highest levels of the PMO. I was hopeful in light of that Liberal members on the committee would want to put the public interests ahead of the interests of the PMO and the interests of the Liberal Party. And what we see today, in fact, is just the opposite. And Mr. Boissonnault, in his comments, spoke about the need to dig in and hear about the remediation agreements and deferred prosecution agreements. Well, you know what? I have to say it's quite ironic, because I wish our Justice Committee had the time to examine deferred prosecution agreements. I wished that had come to our committee, where we could have heard from witnesses, where we could have looked at the merits of deferred prosecution agreements. But guess what? That didn't happen. Why didn't it happen? Because the finance minister, through the budget omnibus bill, decided to sneak it in. So there was no debate. There was no consultation. There was no consideration. And now we know it was because SNC Lavalin was busy begging and pleading and lobbying officials in the PMO. So the fact that Mr. Boissonnault wants to go on at length studying these remediation agreements, I think speaks to the fact that Liberal members aren't interested in getting answers. They're not interested in getting to the bottom of this, because guess what? The policy around deferred prosecution agreements have nothing to do with the issue at hand. The issue at hand relates to whether officials in the PMO put pressure on the Attorney General, the former Attorney General, Ms. Wilson-Raybould, to interfere in an independent prosecution, a criminal prosecution of SNC Lavalin. That is what the issue is. And let me cite, need there be any clarity, the Krieger decision of the Supreme Court that says, quote, "It is a constitutional principle that the attorneys general of this country must act independently of partisan concerns when exercising their delegated sovereign authority to initiate, continue, or terminate prosecutions." Let me also cite the Supreme Court in the Heinz decision, where the court says at paragraph 40, quote, "The decision to initiate or continue criminal proceedings lies at the core of the Crown prosecutor's powers, and the principle of independence of the prosecutor's office shields prosecutors from the influence of improper political factors. Prosecutors must be able to act independently of any political pressure from the government and must be beyond the reach of judicial review. This independence is so fundamental to the integrity and efficiency of the criminal justice system that it is constitutionally entrenched." That is the issue before us, not the policy issue about deferred prosecution agreements that the government didn't bring before Parliament in a transparent way and snuck it through. Mr. Boissonnault talked about solicitor-client privilege. Well, we've said it before, and I'll say it again. The Prime Minister can simply lift the solicitor-client privilege. He has the power to unleash Ms. Wilson-Raybould so that she can come forward and speak the truth. But he doesn't want to do it because, you know why? Because I think when she does, and if she does, he's not going to like what she says. And to the point that was made about, well, we've always had these discussions in camera about witnesses. We've normally had these discussions in camera. Well, guess what? This is not a normal matter. This is about corruption at the highest levels of the PMO, and if Liberal members on this committee want to whitewash it, want to cover it up, want to shut down the opposition and our ability to bring these individuals forward to committee so that we can ask the questions and try to get the answers that Canadians deserve, you're going to have to do it in public. And you can be answerable to your constituents, and you can be answerable to Canadians. And with respect to the point about having a meeting to discuss witnesses, I see the Liberal motion. It has 3 witnesses on the list. We can talk about witnesses. We don't need to wait until another meeting. Why don't we just discuss the witness list today? Let's get on with it. Let's get on with it now. Canadians deserve us to get on with it so that we can bring these individuals before us at the earliest possible opportunity, something that this motion doesn't provide, something that our Conservative motion does provide.
Thank you very much. Mr. Fraser.
Thank you, Mr. Chair. So I think there's a few things here that are extremely important to highlight. First of all, as the chair mentioned, the way that witnesses are generally agreed upon by the various members of a committee, timetable for studies, those are all done in camera. We also have the added element of the sub judice rule, which may, as the motion alludes to, require us to obtain possibly a legal opinion. There are real issues at play here with regard to a matter that is currently before the court dealing with NCN-Lavalin that we have to be very sure that we are not improperly encroaching on an area that is properly under litigation in the courts. We have to make sure that we are doing the right thing. I hear about independence of the judiciary from my friends opposite, but this strikes to the heart of that. If we're going to be encroaching on a matter that is currently before the court, that is the subject of litigation, we have to be really sure that we are not doing something improper as a committee. And so that discussion in the terms of this motion will happen in camera, and that's perfectly normal. That's the way this usually would go. I agree with Mr. Cooper. This is certainly an unusual circumstance. Obviously, having this matter come before our committee in this fashion is an unusual tool to use. We are trying to find a way as committee members to work with them on finding an avenue forward. I believe the motion is clear that we're going to deal with it relatively quickly in camera on Tuesday, February 19th, as the motion says. It's the perfectly normal way that those discussions would happen amongst committee members. I want to also make clear that the purpose of this motion is that future meetings would be in public. We're talking about an in-camera meeting to discuss those issues that are normally dealt with in camera, with the added element of a legal principle of sub judice rule that we have to consider as a committee to ensure that we are not doing something improper. I want to turn to Mr. Poilievre's statement. He talked about lobbying with SNC-Lavalin. I mean, we know that there are oftentimes discussions with politicians and lobbyists. That's normal. We know that Andrew Scheer met with SNC-Lavalin. We know that other politicians met with them to discuss a remediation agreement. We know, as Mr. Boissonnault said, that remediation agreements, or deferred prosecution agreements, as the members opposite have been calling it, are perfectly usual in other countries that we deal with on a regular basis. I think it is important to put in context of the whole context of this situation, the purpose of remediation agreements, which is why my understanding is that it's in this motion. I don't think it's just an aside that we should ensure Canadians understand what the Shawcross Doctrine is and be able to understand what remediation agreements are. But we have to make sure that we're doing it in a thoughtful way. I would note as well that Mr. Poilievre sits on the Finance Committee that would have dealt with the issue of remediation agreements. And I don't recall a discussion at that time that the matter should come to our committee from Mr. Poilievre. I think there's a number of issues at play here that we do need to take seriously. I think the members on this side of the committee are willing to take these matters seriously and work with our friends in the opposition. But going back to the original preface, I guess, of the chair's comments, if there is truly an interest to determine these items, then we need to do so in a way that will have the confidence of Canadians. What I've seen here today, I'm not sure would carry the confidence of Canadians. I will leave my comments at that and say that I will be supporting this motion unamended.
Thank you very much. We will now come back to Mr. Cullen, who had the floor for proposing an amendment.
We're to the amendment now?
Yes.
How exciting.
Monsieur Cullen, vous êtes sur la liste?
Oui.
Mais vous êtes...
You are on the list, but there are several others on the list. I told Mr. Cullen that once we got to the end of the list, I apologize, I didn't understand. Mr. Cullen, go ahead.
My friends, of course committees have the power to investigate. We're doing that right now on Cambridge Analytica and Facebook at the Ethics and Access to Information Committee. Of course we have the power. The question is whether we want to use the power or not. This committee can subpoena witnesses. This committee can deliver findings to the House of Commons and in the full public light of day. The Ethics Commissioner will do very good work, and you'll only see the report. You won't see the interviews, you won't see the questions, you won't see the cross-examination. It bears some suspicion, my Liberal friends, that the only people you put on your witness list are people, 2 out of 3 have already publicly said they don't think there's anything to see here. That's somehow a coincidence, that the witnesses, Randy, you've offered up witnesses already. We're talking witnesses, so we're going to talk about them today. The people that have been alleged to be involved in what is one of the most serious cases that I've seen in my life in politics are not on your list. The people that are on your list that have publicly said, we feel that everything was done properly. In terms of, my friend, the independence of the judiciary, that note should have been passed around the Prime Minister's office some months ago. That if we do respect that, then these allegations that we're now seeing printed in our national newspaper wouldn't have come to light because they wouldn't have happened. That we have very clear rules delineating the ability to try to influence the independence of the Attorney General, to then influence the Prosecution Council. It seems disturbing to me, and to the point around this amendment that SNC-Lavalin lobbied your government exhaustively for, and they spent a lot of money doing it, as they did spending $500,000 in donations to your party, and another 100,000 of which were illegally donated to your party from SNC-Lavalin. Here's what your Liberal member on the committee said about this amendment. What strikes me as being wrong is that these remediation provisions seem to be focused on white-collar crime, or at least limited to white-collar crime. It leaves a bad taste in my mouth, in the sense that it seems we're going to let off people who commit a very serious economic crime, which has very serious effects against those who are not capable of negotiating these agreements in other crimes they might be victims of or perpetrators of. We seem to be letting off people in white-collar crimes with a little slap on the wrist. And here's what the Liberal chair of the Finance Committee said. There is a huge question of whether this should be in the budget bill. Even I will say that. It was slipped into the omnibus budget bill. It was not a financial measure. Who are we kidding? It was lobbied for by a multinational company. They secured that. The allegation is now, did they then lobby the Prime Minister's office to then put pressure on the former Attorney General, Jody Wilson-Raybould, to give them a plea deal so that SNC-Lavalin could keep bidding on lucrative federal government contracts? That's what this is about. They've been banned from World Bank contracts, and if they were found guilty in court of fraud and corruption, bribery, they would be excluded from bidding on lucrative federal government contracts. That's what this is about. Two sets of rules, as your Liberal members on committee, at the Finance Committee said, gave them great concern. Special rules for those who are well-connected, and other rules for those that don't. Average Canadians, those in the middle class and working hard to join it, I think is a popular phrase. The power of this committee to actually find out what happened here is substantial. We are given this role on behalf of Canadians. To simply say this is a sophisticated legal book club, that we can explore and study and contemplate these things, would be to forego our responsibilities when we see something like this here. The witnesses you've offered are suspect in the sense that they've already made themselves known in their opinions on this. The other principal actors, and I'm going to say this now and I'll say it again, we should perhaps stop trying to speak for Jody Wilson-Raybould. We can invite her. We can offer her the opportunity, and she can use her counsel and her very good knowledge of law to decide what it is she will and will not say. The fact that Liberal committee members don't even want to hear from her is telling. If you do want to hear from her, Mr. Fraser, put her on the list. You phoned some other people. You had somebody phone some other people. You didn't phone Jerry Butts. Well, why not? It bears asking. And so to this, what I will suggest is this, that the Justice and Human Rights Committee hold meetings to examine the role of the Attorney General in Canada's system of justice and other pertinent legal matters, and that witness lists include, but not be limited to, the three that have been mentioned already, and including the former Minister of Veterans Affairs, Jody Wilson-Raybould, including Principal Secretary to the Prime Minister, Gerald Butts, including Senior Advisor to the Prime Minister, Matthew Bouchard, and that this committee meet on Tuesday, February 19th, 2019, at a time set by the chair, etc., as per the original motion. If my Liberal colleagues think that hearing from Jody Wilson-Raybould isn't of interest to Canadians, if my Liberal colleagues think that not hearing from the Principal Secretary to the Prime Minister who's implicated in this affair is not of interest to Canadians, and that his senior advisor, Mr. Bouchard, is not of interest to Canadians, I'll let you try to explain that. You can't circle around this whole problem and then suddenly say, we're just not interested in hearing from the principal actors. That makes no sense. And please don't say other witnesses as we may be considered. We're talking about witnesses today, Randy. Let's do it. And if you don't want to do that, if you don't want to have those people invited, we're about to have a vote and you can describe that. But to say, oh, we'll meet in camera and we'll discuss it in private, this is as obvious as the nose on my face. This is something that we got to do. and the nose on my face is pretty obvious. So I think we should get on with it.
Okay, so just so that I'm clear, your amendment, Mr. Cullen, is to add 3 additional people to the existing motion. Is that correct?
I've also suggested rewording in the very first sentence, and I can read it again more slowly if you.
Okay, yes.
That the Justice and Human Rights Committee hold meetings to examine the role of the Attorney General in Canada's system of justice and other pertinent legal matters. The attempt there is to allow for Shawcross, sub judice, those ones that we've all agreed are important. Comma, and that the witnesses list include, but not be limited to, the 3 that are mentioned in the original motion, plus the 3 that I just added. And the final addition is that the committee meet, and I strike in camera from the motion on Tuesday, February 19th, so that we can have an open conversation. I know it's a little unprecedented for this committee. This whole thing is unprecedented. The light of day is our best ally in all of this.
Yeah. Okay, so as I understand it, there's 3 parts to the amendment, basically, but it's all one amendment that you're
Correct.
proposing. You would add 3 additional, take the first paragraph and revise it to the wording that you proposed, and we'll all get a copy of it, and to remove the words in camera from the second paragraph.
From the very last, that's it.
Yeah. Okay, I hopefully will be able to get a copy shortly. So now, I guess we're now on the subject of the amendment. So I have a speakers list on the main motion. Do we now create a new speakers list in the amendment? Or will everybody who wants to speak on the main motion turn to the amendment now? So we have Ms. Raitt.
Thank you very much, Mr. Chair. I will speak to the motion, and I will let the member know that we'll be voting in favor of it. We do think that that is getting to the point for 2 reasons. Number 1, it does deal with the issue of the witnesses that do need to be heard in the situation. And number 2, we will reject any motion that has the proviso that this committee will meet in camera. That will be the clear line for the Conservative side of this committee. The reason being is that it is imperative that we have light shone on this and that we ensure that Canadians get to see what's going on specifically as the witnesses come forward. Mr. Chair, you said yourself that if there was a problem, the Attorney General would resign. You said that many times in the media, and indeed, she has resigned. So therefore, there is a situation here that does need to be studied, and that's why including her on the list of witnesses, as Mr. Cullen has done, makes sense and is actually imperative to our success in getting to the bottom of what happened. Secondly, Mr. Chair, sorry. I'm intrigued by what seems to be a difference of opinion on the purpose of the meeting. Now, I understand that the Liberal side is going to be voting in favor of their motion as unamended, as Mr. Fraser has said. I'll wait to hear what they have to say about the amendment that's Mr. Cullen now. But from the way in which it's been characterized on the Liberal side, they have indicated that Canadians want clarification on the relationship between the Attorney General and the Cabinet, whereas our point of view, and the point of view of most of the editorials in the Canadian newspaper world, is that we want to get to the bottom of political interference in the Attorney General's office. And just a quote from the decision that my colleague Mr. Cooper brought along from Alberta, the part of this decision that caught my attention is the following. The quasi-judicial function of the Attorney General cannot be subjected to interference from parties who are not as competent to consider the various factors involved in making a decision to prosecute. To subject such decisions to political interference or to judicial supervision could erode the integrity of our system of prosecution. I think that's exactly why we want to hear from the witnesses, Mr. Chair, because we want to determine what were the conversations that happened with the Attorney General and whether or not, according to the Supreme Court of Canada, this was something that is of concern. Finally, Mr. Speaker, my colleague... I'm so sorry about that, Mr. Chair.
It's okay.
Finally, Mr. Chair, aspirations are always good. That's good.
I don't know if I can
Mr.
match
Chair,
our speaker, but thank you.
Mr. Chair, as my colleague, Mr. Cooper, has pointed out, and we have not received a response to this, and I think we deserve a response to this, both in the original motion, which has now been amended, but as well in statements made by members on the other side. There's a reference to this unknown group of government colleagues, our government colleagues. And my understanding is that our government colleagues had conversations with the Office of the Attorney General and discussions, so we want to understand what that is, and maybe there's going to be witnesses coming from our government colleagues. But as well, when you were pressed on who contacted the 3 witnesses, because you told us that they've agreed to show up already, that's why it's okay to talk about them as witnesses, we didn't really receive an answer as to who our government colleagues are in that case. I believe that we deserve an answer to who our government colleagues are that contacted these 3, and I will gladly sit here and wait until you give them to me.
So the next one, the next person on the list is Mr.
Point of order,
Sass.
Mr. Chair.
Yep.
I've asked a question. I'm wondering if you can illuminate for us as the chair, because you're in charge of the agenda, who are the government colleagues that called these 3 proposed witnesses?
Yeah, and so number one, the word government colleagues I don't think was previously used. I'll turn to Mr. Boissonnault again to answer that question. But on the issue of the word government colleagues in the motion, the word government colleagues essentially comes from the doctrine itself and and discussions with people in cabinet in the Prime Minister's office and the Attorney General. It's in all of the literature related to the doctrine. That is words that are used with respect to where pressure may be applied and what is permitted and not permitted with respect to discussions between the Attorney General and prosecutors. So the words in the motion are not the words Mr. Boissonnault previously used.
Who are the government colleagues that called the 3 witnesses to determine that they were available?
Again, I will again ask Mr. Boissonnault, since I think it was his office that dealt with that.
So what we're talking about here is people who normally appear before this committee, and colleagues in working in the House Leader's office have been able to work with these 3 witnesses proposed, and there is openness to be able to appear before our committee.
Who in the House Leader's office made the calls to the 3 witnesses who are available to attend?
Are you trying to imply that there's something incorrect with the House Leader's office? Your House Leader's office is working with you right here. So somebody in the House Leader's office called the witnesses. I don't know if Mr. Boissonnault knows the exact name of the person. I don't believe he does.
Mr. Chair,
I've answered the question.
It took me and Mr. Cooper asking the question about 11 times before we got the answer. So forgive me if we are trying to plumb down as to
I don't
who
think
did.
at all we're trying to play down, because there's nothing to hide in that. I think it's perfectly appropriate for the House Leader's office to reach out on the committee's behalf. We work with the House Leader's office all the time. What we've avoided doing, given all of the comments from the Conservatives over the last few days about how our committee would not support any motion, you're changing the narrative now. Before, we were not going to support anything. We were not going to do it. We were not going to shed light on this. Now we are. And you were saying because the PMO would drive us down. We deliberately didn't contact PMO because you guys were saying that we were going to be driven down by them. And I really do want to assert the independence of the members of this committee. I'm very proud of that. And I'm very proud of my colleagues and on all sides, to be honest, in the committee deliberations for the last 3.5 years. I'm so sorry. We're still on the amendment. Ms. Reid has spoken. We now have Mr. Assassi. Then so that everybody knows so you can get ready, we have Mr. Assassi, Mr. Boissonnault, Mr. McKinnon, Mr. Paulus, Mr. Poilievre, Mr. Fortin, and Ms. Kellett. That is the speakers list, and perhaps at that point we might want to consider the amendment with Mr. Cullen having a last word on it, if that's okay with colleagues, and then move back to whatever happens after the amendment, whether other amendments or the main motion or whatever happens, because I think that's a lot of speakers on the amendment, if that's okay with everybody. So not hearing any objection to that for the moment, we're going to go to Mr. Assassi.
Thank you, Mr. Chair. I believe I'm one of the last members to speak today, and thank you for that. Now, I have to say, as I'm sure the other members are well aware, there are many people who think that this committee would be imperfect for the type of exercise that we have before us. I was not one of them, but having listened to my colleagues opposite, I have to say that it does give me some hesitation. The reason for that is quite simple. First of all, what we have heard from some of the members so far has been cherry-picking selective facts, putting them together, and trying to create this impression that something untoward has definitely happened. The reality of the matter is we have heard from our members on this side, and so far we have indicated that from what we have seen, there is nothing to be concerned about. That is our personal opinion. However, that should not be taken to mean for a second that we don't understand that this is important, because the test is not whether we're concerned, the test is whether Canadians are concerned. So in good faith, members have come forward. You're pretending like we're trying to drag this out. We are doing the farthest thing from that. We have agreed to an emergency meeting to deal with this issue. That is actually unique. Mr. Cullen continuously refers to this as something that is unique. Well, it is unique because we understand full well what our responsibilities are. And we have checked our partisan hats at the door. We understand and we share with you the concern that Canadians should come out of this exercise having a much better understanding as to how things work. So I would appreciate it if the members would refrain from impugning our motives. The process that we have outlined here is quite clear. It's quite obvious that the motion that we have presented demonstrates that we would like to join you in making sure that this exercise is beneficial for Canadians. I have heard too often so far people saying that we have, left people off the witness list. Yes, that is very true, because as you will see, the motion itself indicates that we are not suggesting for a second that the witnesses be limited to the 3 people who are named there. We want to work with you. We look forward to working with you. In addition to that, I understand that Mr. Cullen has never appeared before this committee before. I understand Mr. Polyev has never been here. I understand that Ms. Raitt has never been here. I can assure you that every single meeting we have had where we have discussed witnesses has been in camera. So there's no reason to believe. Absolutely. I think if you did check with Mr. Cooper, he will confirm that for you. That is the process we have followed in the past. That is the process we have followed in the past, and we're quite comfortable to do that as well. And if you think we're trying to drag this on, not only have we come to an emergency meeting, but we have indicated full well, we have provided a date in our motion for, and that would be next week, to go over this, to hear your concerns, to share our concerns, and make sure that this is a fulsome exercise. Now, another thing I've seen the members do today is cite principles, legal principles. I can assure you that we're just as concerned about those principles. We want to get to the bottom of this. We will not be dragging it out. So I would please ask the members opposite to actually cooperate with us, come together with us, go over potential witnesses, and meet with us next Tuesday to make sure the Canadians are satisfied that we are doing our utmost to bring some clarity to this. There is a lot of ambiguity out there. There's no question about it. You, I am sure, have read as many accounts as we have. So it's incumbent upon us to not act in a partisan fashion and to try to make sure that this committee actually gets down to work. Thank you.
Sassy, given that was your first opportunity to speak today, I won't draw out that we're talking about the amendment. So if ever all future speakers until we get to the end of this list would also address the amendment in their comments, that would be great. But I very much appreciate your intervention. Next we have Mr. Boissonneau.
Thanks, Mr. Chair, and I'm looking forward to meeting with the regular members of the committee next week. I mean, if you take a look on our side, it's the Liberal members that are normally at the Justice Committee who are here. There's a change in the political dynamic on the other side. I think Snow delayed our NDP colleague. I don't know what prevented the regular colleagues on the Conservative side from being here today, but we'll leave that there. I think that nice to have you here at the committee. It's great. In terms of witnesses, it is our custom to have this done in camera. And I think it would be important if we're talking witnesses, do you want us to talk in public about how the conversations went between SNC-Lavalin and Mr. Singh and Mr. Scheer? Because it was clear? Yes. Great.
Motion to concur. Motion to concur. Yeah.
Because the speculation from the other side, we're
Motion to
talking
concur.
about a downgrade in Mr. Fife's article from 2 anonymous sources to 1. And if you listened to the CBC last week with Carol Off, she was very clear in her interview with Mr. Fife when he said there is no link whatsoever between legitimate conversations between the Attorney General and government colleagues and the fact that Ms. Wilson-Raybould's cabinet responsibilities changed. He could make no link whatsoever. So anyone who's making that link is exercising in rank speculation. So I will also reiterate that the Ethics Commissioner is looking into this issue, and the people that you would like to add to this list are perfectly within the purview of the Ethics Commissioner to investigate and to call to account, to use your language. Our job here is to take a look at the substance of the matter, which is clearly the Shawcross Doctrine, the remediation agreements, because let's take a look at what you're wanting Canadians to see as the smoking gun. If SNC-Lavalin had ended up in a remediation, okay, you'd have something. But guess what? They're going to trial. There's like, are you really serious? Are you trying to make Canadians make that kind of a link? It didn't work in the way that you'd like the fiction to play out, folks. So I will be voting against this amendment and looking forward to meeting with people next week.
Thank you very much. And just that, Ms. Reid, we are happy to have you here. Always happy. I just want to bring back the the camaraderie. I think sometimes these are hard discussions, and sometimes everybody's a little angsty, including myself. So I think it's good to bring the temperature down. Mr. McKinnon.
Thank you, Chair. So I'm listening to a conflation of a lot of unrelated matters to weave a fanciful tapestry of intrigue here. The fact is we don't have any real hard evidence of any wrongdoing to speak of. Mr. Cullen mentioned regarding the witnesses, the people who are alleged to be involved are not on our list, he said. Alleged by whom? We have no one who has come forward who has self-identified as being privy to the kinds of discussions that are underway here, who has, as far as I'm aware, made allegations of any individual. So the notion that people who are alleged to be involved, I mean, the opposition certainly has made allegations of this kind, but these are sort of self-serving, to their position. Mr. Cullen also mentioned that, SNC-Lavalin made $500,000 worth of contributions. That's very bizarre to me because for at least 15 years, that has been impossible. That's been illegal. So I don't know how or where that They still managed to do it. Then they're all illegal, right? I mean, you mentioned 100K as being illegal. These are not legal. They need to be. They need to be prosecuted by the elections commissioner, right?
They were.
But
Both conservatives and liberals returned money for this, but
Right.
but that being said, nothing's been alleged for the last 10 years. They can't donate now, but let's move on from that one. Go ahead, Mr.
okay,
McKinnon.
so I'll stand corrected on that point. But there's also allegations that Ms. Raybould was fired as Attorney General. There's no foundation for that. She went from a senior position to another senior position, a senior position as a Veterans Affairs Minister, where she's in charge of a multi-billion-dollar file, thousands and thousands of veterans who are critically important to Canadians, but also as Associate Minister of Defense. She would get briefed on all the matters pertinent to defense, to be aware of our defense posture and our defense matters all around the world. So it's a great opportunity. It's a coup, frankly, for experience. I can't see how any way this could be construed as being fired. But the notion that she was fired weaves back into this tapestry that the opposition likes to portray, that there's some sort of intrigue going on here. And I don't think there's any foundation whatsoever for that. So we're here today because of this article that was written by Bob Fife and others on the 7th, in which they alleged heavy pressure, urging, and so forth. And they left the impression that kind of any interaction between the cabinet, the PMO, and the Attorney General was illegitimate. Yet on the following day, the same authors quoted also unnamed officials as saying, Canadians should not conflate or confuse a vigorous debate in the Prime Minister's office or among the PMO and members of Cabinet over how to handle SNC-Lavalin's charges with an effort to put pressure on Ms. Wilson-Raybould. A robust discussion is not pressure, one official said. Another official said the PMO had every right to raise a prosecution case with the Justice Minister because a conviction could destroy the company and hurt thousands of workers at SNC-Lavalin. I think that one of the problems here is the impression is out there in the public eye that there has been, because of these kinds of statements, that there is something illicit going on. We have no foundation for that. We have allegations based on somebody's interpretation of discussions that we don't know who they are or whether they're even privy to any of these discussions. I think it's very clear that we must make clear that it is both legal and customary for there to be discussions between the Minister of Justice and Attorney General and colleagues in the government on issues such as the prosecution of SNC-Lavalin in order for the Minister of Justice and the Attorney General to obtain information and advice. The real question here is whether is not whether such discussions occurred, but whether such discussions involved direction to the former Minister of Justice and Attorney General to proceed in any particular way, whether that exceeded the Shawcross Doctrine. That's why it's so important that we study the Shawcross Doctrine so that we can know what those boundaries are and have some idea of what it would take to cross those boundaries. The question has been raised whether or not we should even be talking about the remediation agreement concept. So the original article as well speaks of these alleged interactions trying to influence the Attorney General to abandon a prosecution. And that's absolutely not what remediation agreements are about. Remediation agreements are basically a form of plea bargain, which are available to accused in all manner of aspects of law, criminal law anyway. And it's absolutely not an escape from consequences for their wrongful actions, but they have to admit to the wrongfulness of the action. They have to pay a substantial penalty, and they have to make real and significant changes in their operations to ensure it doesn't happen again. This is not in any way escaping prosecution or escaping the consequences of bad actions. So, on balance, I don't see anybody who actually is privy to these discussions who is alleged to have been making these allegations coming forward. And how can we deal with random people as just a fishing expedition to try and figure out whether there is any foundation for this or not, and then track it down. That is why it is, I think, important that we delve into the nature and purpose of the Shawcross Doctrine, the nature and purpose and the history, perhaps, of the remediation agreements. And I'm very interested to hear from the current Minister of Justice and the other people mentioned in our motion in regard to these broad issues. And if they're able to throw light on other matters, fine, that's great. And perhaps that will lead us into further understanding of who else might need to be talked to as well. So I will be voting against the amendment and in favor of the original motion. Thank you.
Thank you very much, Monsieur Paulus.
Thank you, Mr. Chairman. For 2 years now, we've been beating around the bush. Our Liberal colleagues have been criticizing our eminent colleagues here on this side, but we're talking about something that is absolutely important for all Canadians. Ms. Colleague said that we're here to make political hay, that we're doing this for the media. But I think this is much more important than that. We live in a country under the rule of law. We brought forward a motion, and my colleague brought forward an amendment. Now, we're being criticized for bringing forward a motion including names of witnesses. We've been told that this should be discussed in camera and that one usually discusses witnesses in camera. However, the motion that's being rammed down our throats today includes names. So what? There's going to be there was an in-camera meeting on the part of Liberals with we don't know whom. Here we have before us, for example, the Minister of Justice and Attorney General David Lametti, who I guess must have agreed, the Deputy Minister Nathalie Drouin, and Clerk of the Privy Council Michael Wernick. So in camera, amongst themselves, they decided that we'd put these names in a motion. But today, now we're being told, well, we have to go in camera to be able to discuss the other witness names. My colleague from the NDP has proposed names, but we're being told, nope, we can't discuss it. And we'll vote against because should be discussed in camera. Well, Mr. Chair, this is really a joke. It's a serious situation. Mr. Boissonnault and I believe Mr. McKinnon also said that Bob Fay, Stephen Chase, a professional journalist of the Globe and Mail, would have written fake news? Is that what they're saying? I mean, they're trying to lead us down a funny path. People are talking about the Shawcross Doctrine, about remediation agreements. These are all issues that would be included in the motion. I mean, we've discussed this enough. This is just a show. This is just a show. So, Mr. Chairman, I think that what was tabled by the two opposition parties, mainly the Conservatives, is perfectly noble. We have a problem. There was an Attorney General who had to resign from her position, and now we're being led down a different path through all kinds of procedures. I think we have to get to the bottom of this and deal with it as quickly as possible. Thank you. Thank you very much. Mr. Poilievre.
Committee members across the way have claimed that I'm on the Finance Committee and they had never heard any discussion at Finance about the need to move this new deferred prosecution agreement provision over to the Justice Committee. Well, the members should have read the transcripts because that is exactly what members of multiple parties suggested should happen. In fact, all three parties. Greg Fergus, as my friend Mr. Cullen has said, Greg Fergus, Liberal member from the Gatineau region, raised concerns which my colleague has quoted. I'll quote further. He said, of the agreements, in a sense, then if I steal $10, I'm in trouble, but if I steal $10 million, I can work this out. To be crude, sorry. Furthermore, the chairman of the committee suggested that Finance was not the appropriate place in which such a provision should be discussed. Finally, Conservative Member of Parliament Dan Albus said, and I quote, regardless of whether it was in the budget document, I think that this is not a good provision to have as part of an omnibus piece of legislation, especially to have it in the last section. He goes on, Mr. Chair, I don't know what to say other than maybe we should probably consider hiving this off and sending it to the Justice Committee. Those were his words. That was his conclusion. It was an amendment to the criminal code. It ought to have been discussed here. I find it very interesting that all of a sudden Liberals want to discuss the intricacies of deferred prosecution agreements. They want us to fall into comas, deep, irreversible comas as they drone on about legal theories, rather than talking about the facts of the case that are before us. And the facts are that a massive corporate giant with deep pockets lobbied the Prime Minister's office at least 14 times that we know of. That the Prime Minister's office and the Prime Minister himself then raised the issue of a special deal for that same corporation with the Justice Minister, and then only a month later she was suddenly removed from the position, following which she wrote a letter saying that she had spoken truth to power. It's time she had the chance to speak truth to the people. Canadians want to know. The Prime Minister has the ability to let them know. He can allow his members to vote for this amendment to bring all the witnesses, including his former Attorney General, to appear. And he can waive solicitor-client privilege because he is the client. If he refuses to do that, and if members of the committee vote against having additional witnesses, they will be voting for a cover-up. Because that is exactly what this is. If the members across the way claim nothing that happened in the PMO, in the Prime Minister's office, was improper, fine. Bring the witnesses before us, have them testify under oath to say exactly that. Put all the facts before Canadians and let everyone decide. Instead, what we get are contradictory excuses. One is, they say, we can't talk about witnesses when Canadians are watching. They say those discussions need to happen in secret, in camera, as the parliamentary parlance goes. Funny, then, that their motion talks about witnesses. It lists witnesses that they would authorize to speak before the committee. If they can put forward a motion that lists witnesses, why can't we put forward a motion that lists witnesses, and let's have ourselves a big group of witnesses? The reason they don't want to vote for that is because there are certain witnesses they don't want to hear from. Right? Certain things that might be said that they don't want said when Canadian eyes and ears are watching and listening. Those things have to be kept secret. The journalists, according to the government officials, have to leave the room. The transcripts have to be turned off, and nobody outside of that dark room should have the ability, according to the government, to find out what is said. Well, that is by definition a cover-up, and these committee members representing the Liberal caucus at this committee have the ability to vote in favor of transparency by allowing everyone to speak. So the question is, are they going to help the Prime Minister cover this up, or are they going to help Canadians find out what happened here?
Thank you very much. It's interesting. It's powerful, but it's interesting that the narrative is that we were going to not support any study on this issue and we were going to cover up. Now we have put forward. Now we put forward a motion on the study, and now we're covering up as well. But not what you said. I agree, but you were pretty much alone on that one, Monsieur Fortin.
Mr. Fortin. Thank you, Mr. Chairman. I've been listening to everyone over the past while, and I have before me the agenda for today that says that we're here to discuss political interference in a criminal prosecution by the Prime Minister's office. Interference allegations have been made about the Prime Minister or a member of his cabinet and the Attorney and to the Attorney General. Now, I'm wondering how we can possibly shed light on this without hearing from the person who occupied the position of Attorney General at the time these things took place. So here's what I'm thinking. Would you like us to suspend, Mr. Chairman, or I can wait if you're busy? No, I'm sorry. I should have been listening to you. Sorry, Mr. Cullen and myself were talking about something else. What was your question? No, I didn't have a question. I'm just speaking about the situation. I apologize. I'm listening. Now, we were asked to come here to discuss political interference on the part of the Prime Minister's office involving the Attorney General. Now, the Liberals, with the greatest of respect, are trying to cover this up by deciding that we would engage in a legal course on, for example, the Shawcross Doctrine and remediation agreements. I think everyone is able to do their own reading and understand these concepts. But they're also suggesting that we bring forward witnesses who aren't necessarily people who will be in a good position to testify on the issue of political interference. So here are my two concerns, Mr. Chairman. First of all, I'm thinking of the 4,000 workers in Quebec whose jobs are at stake because of the discussions between the Attorney General and the lawyers of SNC. These are 4,000 workers who are going to be the indirect victims, along with their families, of this whole issue. And this won't necessarily be resolved because our Prime Minister has been a rather amateur in his proceedings with the Attorney General, and also because he doesn't necessarily want to waive solicitor-client privilege to allow her to appear. If there's one person that we should be listening to, it's Judy Wilson-Raybould. I don't see how we can proceed any other way. I was looking at the list of witnesses, but I have the impression that I'm getting ready to go on a trip, but I have no idea where I'm going. Perhaps I have to pack everything. I have to pack my fishing rod, my swim shorts. I have to pack all kinds of things, but I have no idea where we're going. But there's a name that keeps coming back over and over again. That's Judy Wilson-Raybould, the former Attorney General. And she's the one who supposedly would have been the victim of political interference on the part of the PMO. So she has to come before us and tell us who did what, who asked her to do what. And if she can do that, then perhaps we can come up with more relevant witnesses. In my opinion, in fact, the Liberal motion is just a red herring. My problem is that actually what we're doing here is putting SNC-Lavalin on trial. But you know what? That's not what we're supposed to be doing. Yes, their executives were involved in bribery, etc. They're going to have to pay for that, and they should. People who commit fraud have to pay for it. Now, should the business itself be sanctioned? Yes, but there are procedures. We'll see if there's going to be a remediation agreement. We've been told that apparently perhaps there could be a remediation agreement. I'm keeping my fingers crossed, not for myself, but for workers and their families, 4,000 workers and their families who might be out of work simply because we can't come to an agreement so that they can keep their jobs. And now the Prime Minister, an amateur, is not allowing the former Attorney General to come and speak on this situation. I'm shocked by this. Now, I don't want to have to do the job of the Attorney General or the SNC lawyers. I don't want to have to do the job of the Ethics Commissioner. They all have their own mandates. But here in this committee, we should be considering the issues of political interference by the Prime Minister's office. And the first person, and maybe the only person, if we're only going to listen to one, should be Judy Wilson-Raybould. Thank you very much. And thank you very much for your comments on the workers and employees of SNC-Lavalin, because you're right, it's very important for them. It's very important for Quebec, and it's a very important business. I'd just like to move on now to the next person. There was Ms. Callig who wanted to speak, and Mr. Boissonneau, and then Mr. Cullen will be wrapping up on his amendment, and then we'll be going back to the main motion. Thank you. So, Ms. Callig.
Thank you, Chair, and merci à Monsieur Fortin pour votre commentaire.
Thank you, Mr. Fortin, for your observations.
With the premise, but I would appreciate if you would come to our committee a lot more and shed light on the important issues that we discuss. And I really would love to have this kind of attention in our committee for the very important issues that we have gone through, such as human trafficking, which was our latest study, providing recommendations on how to deal with the very important and very tragic issue of human trafficking across our country, with access to justice, and how do we ensure that Canadians, middle-class families, have that access to justice. And I think that really comes to the crux of the issue as to what in-camera really does for a committee. It takes away the partisanship. It takes away the political posturing, which we have been privy to today, and it allows us to have frank discussions to see what will be the most fruitful people who can come forward and speak to the issues that we have before them. I think Canadians have a right to know, to seek that clarification through our committee, and I think that our committee owes it to Canadians to not be so partisan, to not be here looking for sound bites, to be able to try to embarrass persons or to embarrass our Prime Minister or the Prime Minister's office at all. I think we need to put that aside. We need to put that partisanship aside. We do need to come to the table with hopefully the permanent members of the committee and discuss at length who will be the most fruitful people to really speak to the issues that are before us today, and would love to have Canadians in really what they have voted for us for is to represent them, to speak for them, and I hope that we can give them what they have really voted for, which is impartial, honest representation of their needs and their demands and their wants through this impartial committee. And I hope that our members across the way can really support that. I don't think that we're doing that we should be changing the way in which we conduct ourselves just because the cameras are on. I think that we need to have that impartial discussion. And my fear is that if the cameras are on, my colleagues across the way will not be able to shut off their partisanship. And that's why I don't support the amendments as proposed by Mr. Cullen. Thanks, Chair.
Thank you so much, Ms. Khaled. Okay, so last speaker, and then then Mr. Cullen to finish up on the amendment is Mr. Boissonnault. Then we go to Mr. Cullen to finish up his closing remarks on the amendment, and then we'll vote on the amendment.
Merci, Monsieur le...
Thank you, Mr. Chairman. I think it's important to speak to Mr. Fortin's observations. I absolutely agree that it is not our mandate, and we don't have the means to be putting SNC-Lavalin on trial. There are other areas that can be done in. But I think it's very important to talk about some facts. The Attorney General did not resign, and she wasn't fired. A cabinet member who had a position as Minister of Veteran Affairs resigned. Now, a former Attorney General cannot speak to their experience because that is not her most current or recent mandate around the cabinet table. Now, on Mr. Poilievre's point, on the 7th of November, the Justice Committee dealt with the issue of remediation agreements, and Member Nicholson, Fraser, and Rankin and the chair spoke about it. So it's not correct to say that this issue was never raised here within the Justice Committee. And with all respect, with all due respect for my Conservative colleagues, when they spoke about our witnesses, I checked, and Mr. Lametti will appear before our committee. He said in public that if ever the committee called him to appear, he would. Now, no one in the leader's office called those witnesses, but given that Mr. Wernick and Ms. Drouin are civil servants, if they are called before a committee, they appear before the committee. It is common procedure to make those calls. So I have to say I misspoke in that case, and I apologize. Thank you, Mr. Boissonnault. I'm now going to give the floor to Mr. Cullen so that he can speak to his amendment.
Amendment to combine the interests of hearing from the relevant people. So far I've heard from Liberals that they're not interested in inviting Ms. Jody Wilson-Raybould to talk. Well, you're about to vote against my motion, which asks her to come as a witness. You could, that is true then. See, you can say something's not true, but then you, okay, so so my Liberal friends who are trying to help me here, I think, Chair. The suggestion is then the next Tuesday in camera, we're going to put Ms. Jody Wilson-Raybould on the list. We will discuss it. So we're discussing it right now. And yet, with the cameras on and people witnessing our conversation, you won't commit to it. You understand the difference between discussing something and committing to something. And you also understand the difference in just trust me isn't going to work on this particular conversation, because just trust me is what the Prime Minister was doing. And to the comment that we're here to try to embarrass the Prime Minister, he's doing that all on his own. He doesn't need my help. He doesn't need any of our help. He's conducting himself in the way that he thinks is best. And I, frankly, as I commented before, think his comments have been beneath the office of Prime Minister when he literally stood in front of buses to talk about how terrible Jody Wilson-Raybould was in her role and how she disappointed him. My goodness. Misunderstanding the role of Attorney General entirely. Fine, I'm sure you'll have a briefing. One quick comment, Chair, to you, because sub judice, something before the court that we would worry about impinging upon, thankfully, 35 years ago, we had a ruling from a Speaker of the House of Commons. And I'll read it just to give committee members assurance that we can investigate this case while it's going on in court. The House has never allowed the sub judice convention to stand in the way of its consideration of a matter vital to public interest or to the effective operation of the House. Anyone want me to repeat that? Yeah, I do. Okay, yeah, so the House has never allowed the sub judice convention to stand in the way of its consideration of a matter vital to public interest or to the effective operation of the House. So we've had 35 years in which we've lived under this rule as parliamentarians. We're quite comfortable with it. And so the motion that we put forward today, that I put forward today, was an attempt to combine the concerns raised. Now, to my friend Mr. McKinnon, if the only witnesses we ever invited to committee were those that self-identified them in the middle of a fraud, we'd never have witnesses at committee. We can't necessarily wait for them to put their hand up and say, oh yes, I put pressure on the former Attorney General of Canada, please invite me to your committee. Sometimes we have to go out and seek them. Now, Mr. Bouchard met 15 times with SNC-Lavalin to talk about, what did he talk about? Justice and law enforcement. This company met over and over again with senior members of the Prime Minister's office to discuss justice and law enforcement. That's an incredible interest in justice and law enforcement coming from a construction and engineering company. If there's nothing untoward here, which is what Liberal members keep telling us, the first accusation my Liberal colleagues have made is that opposition members are making accusations without evidence, and then go on to say that evidence can't be true because of your unfounded allegations, that somehow the Prime Minister said this and so then everything must be clear. The Prime Minister's arguments have not worked out well. If you want to alleviate the suspicions of Canadians that there is the potential of any effort to cover up, I'm not suggesting the PMO is instructing you to do it, you might be just doing it on your own. If you want to alleviate that suspicion, then allow Ms. Wilson-Raybould to come forward. Allow the Principal Secretary to come forward. Allow Mr. Bouchard, who met 15 times with SNC-Lavalin, to come forward. It's frustrating for me because, to Mr. El-Sassi's point, I'm not going to give you too much credit for showing up. You had to show up. The opposition members have the authority under Section 106.4 to call a meeting like this. I'm glad you're here. I'm glad we're talking about this. But in the attempt to find some joint resolution that would allow us to do a proper investigation into this, because that's what committees do from time to time, Liberals seem to have dug in and said, we're only going to invite these 3 witnesses. Yes, because when I've suggested other witnesses, you're just about to vote against it. So that then is true. If you later on Tuesday in camera decide that the witnesses I've suggested or my colleagues from the Conservatives suggested are now important to you because they're at the center of this matter, then wonderful, we'll go from there. But we have this opportunity here today, and you haven't even bothered to phone them or had someone phone them or whatever the case may be. It is interesting. We want to study remediation now after it's already passed into law. And in terms of the offer, I think Mr. Boissonnault made the offer to discuss. I won't speak for the Conservatives, certainly, but if he would like to hear what we heard at the SNC-Lavalin meeting with some of my colleagues, I'd be happy to show you ours if you'll show me yours. We'll in fact come forward and tell you everything that was discussed at that meeting, because I know the result of that meeting. When SNC asked for this special plea deal to be worked into a budget agreement, we told them no, and then we voted against it. You folks put it into an omnibus bill, and which your own committee members sitting on that finance committee found inappropriate, and you still pushed it through Parliament. So actions speak just as loud as words here. Lastly, I'll say this committee in particular, has a solid and well-deserved reputation of trying to find common ground over sometimes very tricky and difficult issues with regards to justice. It's held up as one of the higher committees. The amendment to this motion that I put forward today, Chair, was in respect to that tradition. I don't know if the accusations of partisanship and whatnot were also directed at me. It doesn't really matter. But to vote against what I think most Canadians would see as a pretty reasonable amendment. If you're open to hearing from Ms. Wilson-Raybould, then vote for it. If you're open to hearing from Mr. Butts, then vote for it as well as Mr. Bouchard. If you're not, then you'll vote against it. And those actions will speak louder than your words. So with that, I move my motion as amended to the central motion brought by the Liberal Party.
Chair, I'd ask for a recorded vote and let the record show that anyone who votes against Mr. Cullen's very reasonable amendment is voting in favor of a cover-up.
Okay, that statement is unbecoming of you, Mr. Cooper. I'll just leave it at that. Mr. Clerk, we'll proceed with the vote on the amendments.
Merci, Monsieur le Président. Donc, la question...
Thank you. The question is on Mr. Cullen's amendment. Mr. Boissonneau.
Mr. Fraser? No. Ms. Khalid?
No.
Mr. McKinnon? No. Mr. Barrett?
Yes.
Mr. Cooper?
Yes.
Ms. Wright?
Yes.
Mr. Cullen?
Yes.
Yeas 4, 4, nays contre 5.
So the amendment was moved and it's defeated.
On the principal motion, colleagues, the meeting, let me just, the meeting was originally scheduled for 2 hours. We've now passed that point. My question for you is whether or not everybody is prepared to limit the remaining speakers to those on the list or whoever puts up their hand right now, and then we will move to a vote on the main motion. The people who are now on the list are Mr. Barrett, Ms. Khalid, and Mr. Fraser. Can anybody, Mr. Cooper, Mr. Polyev, anyone else? Mr. Cullen, Mr. Barrett, you're already on the list. Is there anyone else? Mr. Boissonneau. Okay, so speak now or forever hold your peace, everyone. Tout le monde. Monsieur Fortin. J'imagine vous serez la...
I imagine you'll be the last one to speak, Mr. Fortin. So I hope you'll leave us with wise words. Oh, I only speak wise words, Mr. Chairman. I don't always say them wisely, but they are only wise words.
Who is next? Mr. Barrett.
Okay, thank you very much, Mr. Chair. And so the opposition parties put forward a motion to be considered here today, and 2 hours and 15 minutes into the meeting, it's not the motion that we're discussing. As is your prerogative, you recognized a Liberal member of the committee and the motion that they had put forward. And as a new but regular member of the Standing Committee on Justice and Human Rights, and with a consideration to your comments at the outset about the common ground that members of this committee have traditionally been able to find in furthering the business and the good work of this committee, I would have hoped that with the motion put forward by the Liberal members, and at the outset stating that they were looking for some common ground to be built around that the very reasonable amendment put forward by Mr. Cullen would have been given more consideration than just outright refusal, which is essentially what happened. This was a clear cut right down the middle of the room as far as support for and against. However, there still is an opportunity, though the Liberal members do hold the majority on this committee. They have the opportunity with the motion that they've put forward to make an amendment and not to hold the consideration and selection of witnesses in secret next week. And though it may be a convention or tradition that those deliberations are done in camera, that there is an opportunity in these exceptional circumstances to avoid the perception that there is something to hide, and that they amend their motion to hold those discussions in public, and that they give themselves the opportunity to not not position themselves in the light that is pretty clear that they've got something to hide, and that the witnesses put forward are very reasonable and very germane to the subject matter. So I think that with a view to the motion put forward by the Liberal members, that that very simple adjustment ought to be made.
Thank you very much, Mr. Barrett. Next person was Ms. Khaled.
Thank you, Chair. I really think that that we must come to a decision and have a vote on this on the motion before us, which I think really speaks to what is the substance of what the parties opposite and what us impartial members on the Liberal side, as well as Canadians, really hope to look into in understanding what the nature of the relationship is between the Attorney General and government and the Prime Minister's office, including cabinet ministers, etc. I think that we should go ahead and move to a vote immediately, and that if I had better faith or more faith in the members across the way, if with respect to their political posturing, would be happy to have this discussion in public. But I really fear that that they will use their tactics as they've shown over the past number of days to make this a very, very heavy political issue, and then to really impede the truth-finding exercise that we are about to embark upon. So I hope that we can move to a vote on this motion immediately, the motion that is before us. Thanks, Chair.
Thank you so much. Mr. Fraser.
Thanks very much, Chair. Just a couple of points. First, I know this has been the subject of a lot of discussion today. I do think we should vote on the main motion. I just want to be clear on a couple of things. First of all, the fact that, again, just to reiterate, the fact that going in camera to discuss a potential legal issue, and I respect Mr. Cullen's point there, but on the sub judice principle, we don't have that information at our fingertips right now in order to make a decision on that. Those are normally things that would be discussed in camera. That would be perfectly normal, as well as timetable to look at other issues that this committee may or may not be dealing with. We generally would have those discussions in, or we would always have them in camera, as well as other witnesses. So I think it's important people understand that that meeting, in order to have those discussions regarding things that are very important for this committee to consider before embarking on this study, is needed to be done in that fashion. And then, of course, any meetings flowing from that will be in public. That I don't want to leave the false impression that we're talking about having meetings in camera that this study is going to undertake. So I think that's an important point, and I'll leave it there, Mr. Chair.
Thank you very much, Mr. Fraser. Next, have Mr. Cooper.
Well, thank you very much, Mr. Chair. And in the 3.5 years that I've had the privilege of serving on this committee, we've had a number of good days. We've gotten a lot of good things done in which we've been able to put aside partisan differences and look at what is in the best interests of Canadians, the best interests of the law. But I have to say, this is not one of those days. This is the most disappointing day that I've had on this committee. I really did believe, and Mr. Chair, you said that members, that we just dismissed this committee exercise out of hand with respect to our motion. Not true. I had said many, many times publicly on the record that I had faith in members on the Liberal side, that they would put aside partisan differences. They would put aside what is in the interests of the PMO and do what is in the interests of Canadians. Sadly, Mr. Chair, I learned today that on this issue, I was wrong. What we learned today is that Liberal members on this issue which speaks to corruption at the highest levels of the PMO, are nothing more than agents of the PMO doing the bidding of the PMO. How do we know that? Well, very simply, when I, along with Ms. Raitt, asked a very straightforward question about how did these three witnesses, the Attorney General, the Deputy Attorney General, and the Clerk of Privy Council, appear on the list of witnesses to call to the exclusion of individuals such as Gerald Butts. Well, there was a lot of confusion over there. It was pretty clear that Mr. Boissonnault hadn't drafted the motion, but we got the answer that it was apparently the government House Leader's office that was involved. In other words, the government House Leader was directing what Liberal MPs on this committee would bring forward, and so there we have it. There we have it for the record. It's very clear, it's very plain, but this is not a committee that, on the Liberal side, that is acting independently and for the interests of Canadians. That's sad. And let the record also show that when it came time to voting on Mr. Cullen's amendment, Liberal MPs voted against calling Gerald Butts, who met with SNC Lavalin on multiple occasions, including on issues related to justice and law enforcement issues. When given the opportunity to call Mr. Bouchard, who again met with SNC Lavalin multiple times on justice and law enforcement issues, Liberal MPs voted no. And when it came time to voting on whether to call perhaps the most important witness, that of former Attorney General Jody Wilson-Raybould, Liberal members voted no. Mr. Boissonnault, parroting the Prime Minister's lines, cited the issue of solicitor-client privilege. And the simple answer is that the Prime Minister can waive that privilege. And I would hope that in the interest of getting to the bottom of this, that Liberal MPs would agree that it's important that the Prime Minister stop the cover-up and unleash the former Attorney General. And so with that, I would like to propose an amendment to the motion Mr. Chair, I will read my amendment, that the committee call on the Prime Minister to immediately waive any solicitor-client privilege involving.
I have a point of order. I have a point of order. Sorry, I don't know where it came from, but somebody said point of order. Mr. McKinnon.
We are well past time that we've allocated for this, so this meeting should have ended 15 minutes ago. I'm happy to vote on the main motion.
Cover-up.
Okay.
It's a cover-up, and it's becoming clearer by the day. I have an amendment.
I think what's becoming. I think again, number one, that's Mr. Cooper had the floor. As far as I know, he's perfectly allowed to put an amendment while he had the floor, even though I thought we had an agreement beforehand that we were going to have these speakers and we were going to vote on the main motion. However, absolutely, we can have an amendment. So we can continue with this list, and then hopefully we can both vote on the amendment and the main motion, and actually go through this meeting and come to some conclusion today. But Mr. Cooper, you have the floor.
Yes. Well, before I was interrupted, I will again state my amendment that this committee call on the Prime Minister to immediately waive any purported solicitor-client privilege involving the former Attorney General Jody Wilson-Raybould in respect of the SNC Lavalin matter, so that Ms. Wilson-Raybould can speak.
Yeah, I'm wondering if it introduced like a new.
Give that, please. Yeah, no, I understand. I'm trying to determine if that is within the scope of the motion. Sorry, I'm once we have it, we'll make that determination, or even I mean. Well, yes?
Yes. So the reason that this is in order is because one of the witnesses may, of course, be Jody Wilson-Raybould. She is at the center of this matter, and for her to testify in this committee, that it would be good for her to have legal certainty that she is allowed to speak freely. So this amendment is just simply a friendly amendment to what the government has put forward. And I don't see this one. Not only is it consistent with having hearings, but it is consistent with the intention of the original motion. So it is in order.
Well, again, I understand the link to the potential testimony of a potential witness before the committee. However, I'm still having. I need to see how it's formulated and where in the motion it is. So I'm going to reserve judgment for the moment on whether or not it's receivable. We'll go to Mr. Poilievre. Were you planning to speak to that issue, or were you planning to speak to the?
I can speak to the main motion.
Okay. Well, why don't you speak to the main, so we don't slow you down, and then I'll let you. I'll try to rule while you, at the end of that, and I'll give you a chance to go to.
Good job.
I shouldn't be telling you what I think would be, but what would be in order if you suggested that at that meeting that subject be introduced. But I don't know that adding that at the end of that line. I mean, it's talking about what we're doing at a Tuesday meeting. I appreciate it. I don't think that it's within the context of the motion. I would tentatively with this. Sorry.
You're fine.
Put it before that.
Still, wherever it is, if you found that it
Just vote against it if that's how you feel.
If you want to cover it up, you just
Again,
yes or no?
I think there's going to be ample opportunity. What I'm going to say is I think there's going to be ample opportunity to introduce that motion at subsequent meetings outside of being an amendment to this motion, and I think it's extraneous to this motion. That's the clerk's belief in mine. I'm going to rule that out of order. However,
Mr. Chair,
Mr. Poilievre,
point
please,
of order.
I'm making a ruling, so please let me make the ruling. I will allow you to introduce that as a separate motion at the earliest possible moment. So once we finish dealing with this motion, I will be prepared to let you raise that as a separate motion.
Today.
I have no problem. I have no problem as long as we limit the time frame. Yeah, absolutely. I think that's the fairest thing. I have no problem that we discussed it, but I'd rather deal with this motion and then bring that as a separate motion. Okay. Mr. Poilievre.
Thank you very much. And listen, I know that the government members on this committee would like to cover this matter up in a manner as inconspicuous as possible. That's why, of course, they're asking for the discussions on the future study to happen in a secret meeting. And I have heard them, they're heckling, and so are their supporters in the gallery heckling whenever we point out that fact. But the reality is that the principal player at the heart of this matter is Miss Jody Wilson-Raybould. She is the former Attorney General. She has she has resigned in order to preserve her integrity after a series of highly suspect activity that we now know occurred. And that activity, of course, is 14 meetings between SNC-Lavalin and the PMO, meetings between high-level PMO officials and Ms. Raybould, including discussions involving the Prime Minister himself, all regarding the possibility of a special deal for a large accused corporate criminal. And she has, in a highly unusual move, resigned from cabinet, said that one of the reasons why she believed she was originally moved from her position is because she spoke truth to power. All of the only point in even holding these discussions is if we can hear from her. But yet the Prime Minister is silencing her He's using his legal authority to prevent her from speaking because he's afraid of what she has to say. So what Conservatives are asking, what Canadians are asking, is let her speak. Now, the Prime Minister is the client. Client can waive solicitor-client privilege. I don't even know why this is a matter of controversy for members across the way. If they want the truth to come out, then they would be willing to, without hesitation, to support a call for the Prime Minister to do that. And so I conclude my remarks with a motion that the committee call on the Prime Minister to immediately waive any purported solicitor-client privilege involving former Attorney General Jody Wilson-Raybould in respect of the SNC Lavalin matter, so that Ms. Wilson-Raybould can speak. Thank you.
Thank you. We are currently dealing with another motion, so you can't move a motion at this time. We're debating an existing motion.
Was it an amendment?
No, he's not proposing an amendment. He's proposing a totally new motion. You can't, I already ruled that it would have been out in order as an amendment, but that I will entertain it as a new motion following the discussion on this motion and the conclusion of the discussion on this motion.
But I believe with unanimous consent, we can allow it to go ahead.
Do I have unanimous consent?
Yes.
Okay, well, we do not have unanimous consent.
Note that members of the Liberal side refused to provide unanimous consent for this motion to go ahead.
Yeah, as a normal matter, of course, yes. Okay, we are now with Mr. Cullen.
Huh. I like the introduction, Chair. That was very enthusiastic.
I always do an upbeat introduction for you.
Oh, wow. I'm blushing
Now,
now.
Rankin gets ovation,
So
but you get it.
It feels to me, I buy my kids one of those, connect the dot books. You follow one number to the next. But for anybody who's ever done it before, you flip the page and you can clearly see what the thing is. But little kids get the enjoyment of actually connecting all the dots and then realizing at the end what the picture is. It does baffle me that my Liberal colleagues have seen the events of the last 6 days and say, clearly there's nothing untoward here. Where every Canadian, many former attorneys general, many law experts have told us that obstruction charges are brought with less evidence than what we've seen already in this, because the gravity of what we're talking about is so severe. I appreciate my friends talking about their independence, talking about the need to reassure Canadians that everything is fine. The best way to do that would be in the most transparent manner possible. We clearly know that Ms. Wilson-Raybould should be invited to this committee to tell us from her perspective, given the limitations that the Prime Minister's privilege puts upon her ability to speak, and Liberals just voted against it. Don't keep saying that you didn't when you just did. The facts, you're entitled to all your own opinions, but not your own facts. And the facts of the matter are clear, that we just offered to invite Ms. Wilson-Raybould to the committee, and now we're back to this motion where the current Attorney General has already publicly said he doesn't believe there's any evidence to allow an investigation, and has also said that he hasn't spoken to Ms. Wilson-Raybould at all or anybody else that's involved in the allegations that have existed in the newspaper. So this is as one pundit has said, is a bird box investigation. You're looking without looking by intention. Let's not place a blindfold on the committee and then say we're doing the good work of the public. Let's not put these limitations down and refuse the principal actors in this play and suggest that we're somehow doing our best due diligence. That's just not true. You can justify it however you want and pacify yourselves, but that's clearly not what's going on. I came today with the clearest intentions to find some space in between what the Conservatives had proposed, a more exhaustive list, frankly, which may have been actually more complete and satisfying. And then we saw, without consultation, the Liberals come forward with a very, very limited list of witnesses, some of which have already told us that they already think nothing untoward has happened. And then the potential of a very exhaustive study into some things that we already know, for example, sub judice rules. I can read the Speaker's ruling again if my friends would like. As an attempt to, I hope not delay justice, because when you delay justice, you deny justice. We know that. This committee better than most. And it feels to me like every scandal I've ever watched, it's the incident itself, and then it's the attempt to hide from any sort of responsibility that is sometimes greater than the initial incursion. And Canadians don't stand for it. And I know none of my colleagues were here during sponsorship or any of those days, but the lines from Liberals sitting at tables like this said there's nothing to see here. There's nothing to see here. Nothing untoward has happened. I believe the Prime Minister when he said no money went to special interests in Quebec during sponsorship. And that just wasn't true. So it's disappointing. I know I'm not a standing and permanent member of this committee, but knowing the work that you've done, knowing Mr. Rankin's contribution, we came into this meeting with hopes that has now become a faint hope. That next Tuesday, in camera, behind closed doors, suddenly Liberals will believe that hearing from Jody Wilson-Raybould, hearing from Gerald Butts, hearing from Mathieu Bouchard and others that met extensively with SNC-Lavalin to talk about criminal affairs will suddenly happen. I hope it does, but that hope has become much fainter today. I'll be opposing this motion because it doesn't do what I believe this committee's job and responsibility is, which is to work on behalf of Canadians to put some light on this sordid affair. Thank you, Chair.
Thank you very much, Mr. Collin. Monsieur Fortin.
Mr. Fortin. Thank you, Mr. Chairman. I'm not going to repeat everything I said earlier, but obviously I agree with the amendments that have just been brought forward. You know, we can't do this kind of work without them. I mean, I'm just looking back at the agenda. We were supposed to discuss the request to study reports of political interference, and we can't do this without hearing from the most important individual, that person who would have been the victim of that political interference. Anything else is just a waste of taxpayers' money. It's a waste of time. It's just beating around the bush. We can listen to any number of witnesses, and we'll ask them if they're aware of whether or not Ms. Wilson-Raybould was under pressure by the PMO. And they'll all tell us, well, ask her yourself. We don't know. So anywhere, even in small claims court, you have the main person involved come forward. And I appreciated what you said, Mr. Chairman. You said you were inviting everyone to come forward and participate in a collegial fashion. So your words are very wise. And so I'm going to repeat your words back to you. Let's stop this unhealthy partisanship. You know, if we're talking about a cat, let's meet the cat. Let's see the cat. So I think anything else is just continuing to beat around the bush. Now, I'd like to wrap up with wise words. So I'm going to say that I did like Mr. Boissonneau's suggestion that I come here more frequently. And so I'd just like to point out that the Bloc Québécois would be very happy to be recognized as a full-fledged participant in your work. We'd be very happy also to be acknowledged in the House. So if that's your offer, well, it gives me great pleasure to hear you say that. And perhaps we should wrap up on a historic agreement to recognize Bloc Québécois. Thank you, Mr. Fortin. It's Ms. Kalig who said that, by the way. Well, I still have Mr. Boissonneau on my list and Mr. McKinnon. Thank you, Mr. Chairman. I think it's very important before we vote to look at the main motion once again. It's very important for us and for the country to understand what remediation agreements are. It's important what that represents, what it means. And the Shawcross Doctrine is important to all Canadians because what it does is set out the parameters of conversations between cabinet colleagues and other departments. So I think it's very important to understand the basic principles and that we have the right people before us to come and testify before the committee on this matter. Now, despite the fact that Mr. Cullen said that we have sub judice rules and that we've had them for 35 years, I think it's very important to talk about what that means in 2019, especially when you're talking about two different court proceedings. We have to look at these rules very closely. We cannot jeopardize court proceedings under our legal system. It's critical, and it's one of our main responsibilities. with respect to client solicitor privilege, it's also very clear that the Prime Minister has asked David Lametti to consider this issue. It's very complex. And our colleague, the Minister and Attorney General, has to be able to provide sage and wise counsel to our Prime Minister. And that request has already been made.
Issue of in camera and colorful language from the opposition about secrecy. Let's be clear and put on the record that in camera discussions, the results are known, the decisions are known after the meetings. And so we have to make sure that we're able to talk about these sensitive matters in confidence among members of this committee. And I look forward to seeing the regular members once again. And to Mr. Cooper's point.
Sorry, Mr. Boissonnault, just a small point of order. Just very brief. What Mr. Boissonnault just said is not entirely correct.
Which?
Only that all decisions that are made in camera are known. Only positive decisions are known.
We will have positive decisions about a witness list. That will be known. We'll have positive decisions about the timeline of the study.
My friend is a very intelligent person. He knows what I'm referring to. If the committee rejects the proposals that are put forward in camera, that is not known.
Well, I'm confident that we will have positive results in the meeting next Tuesday. Now, to Mr. Cooper's comment, I may be colorful, but I'm not a bird. I don't have nearly enough plumage. And so my colleagues are my own. I am no parrot. My comments and my work here today are my own. And this motion was crafted by Liberal members of this committee this morning. And if you would think that there was a cover-up going on, we would have just shut this down at 3:10. Let's be serious. And Canadians know that. If there was some desire from our side to not shine a light on this, to not look at this, to not have 3 witnesses in good faith on the list today, we would have shut this down at 3:10. And so to say anything else is just to continue the memes and the social media bullying that you have coming to all our offices. If that's how you want to play this, then go ahead. But we will make sure that we do this sensitively, responsibly, and understand that we can get to the bottom of this on behalf of Canadians. That's our job.
Thank you very much. I appreciate that. We'll now go to a vote on the main motion. I'm sure somebody will want it to be recorded.
Recorded vote,
Yeah.
and let the record show, but a vote in favor
Okay,
of this motion.
we're not going to do that again.
Cover-up.
That's out of order for a number of reasons. Mr. Clerk, please take the roll on the main motion. Those voting in favor support the main motion put forward by Mr. Boissonnault. Those voting against do not support it.
Thank you, Mr. Chair. Monsieur Boissonnault.
Mr. Boissonnault.
Mr. Essasi. Mr. Fraser.
Yes.
Ms. Khalid.
In favor.
Mr. McKinnon. Yes. Mr. Barrett.
Against.
Mr. Cooper.
Against?
Ms. Wright.
Against.
And Mr. Cullen.
Opposed.
Yeas pour, 5-5, and nays contre, 4-4.
Thank you very much. That motion is carried. Now, I've promised Mr. Cooper he can put forward a different motion. I've been told by colleagues that there's travel issues. So I'm wondering if we can let Mr. Cooper put forward his motion and agree to come back to that motion on Tuesday, coming out of camera, following whatever part we do in camera for this meeting, and go out of camera to go into Mr. Cooper's motion on Tuesday so people can make their flights.
Well, Chair, with the greatest respect, this is a very straightforward motion that really shouldn't require a lot of debate. In fact, we can proceed immediately to a vote right here, right now. And I would hope that Liberals would do the right thing and let Ms. Wilson-Raybould speak. That's all.
Okay, sir.
Yeah,
Mr.
so-
Does everybody have a copy of this motion? If you can read it, please. So, and nous avons pas français.
We don't have the French version, I believe.
Call on the Prime Minister to immediately waive any purported solicitor-client privilege involving former Attorney General Jody Wilson-Raybould in respect of the SNC-Lavalin matter so that Ms. Wilson-Raybould can speak. Mr. Boissonnault, do you have any procedural...
Just to reiterate what I said in French, Mr. Chair, the Prime Minister has asked the current Attorney General to look into this matter, and that this is a very serious and specialized issue of law, and that it requires the right analysis and examination, and that the current Attorney General Honorable David Lametti is looking into this on behalf of the Prime Minister. I think that is where it should reside.
Sorry, I was just wondering, I thank you, Mr. Boissonneau. I was just wondering if we were allowed to vote without the French version, but we apparently can.
Yeah, I think we should just proceed to a vote and let everyone.
Non, généralement, notre comité.
Generally, as you can see, our committee does try to be bilingual. There are two official languages, French and English. We do have simultaneous interpretation. Well, in our committee, we do really do our best to be bilingual, and I wanted you to know that, says the chair.
I'm sure a recorded vote.
Yes, a recorded vote, and everyone can catch their flights, and we'll know who's on the side of getting answers and who wants a cover-up.
Oy vey. Oy vey. Okay. Mr. Clark.
OK, thank you, Mr. Chair. La question est donc sur la motion.
The question is on the main motion as moved by Mr. Cooper. Mr. Boissonneau.
Mr. Isasi. Mr. Fraser. Ms. Khalid.
No.
Mr. McKinnon.
No.
Mr. Barrett.
Yes.
Mr. Cooper.
Yes?
Ms. Raitt.
Yes.
Mr. Cullen.
I'm voting for the motion, but against the cover-up. Is that right? That's correct. That's correct. Okay. Just wanted to know yes to no.
Yes
Nice.
pour 4, nays contre 5.
Parfait.
Then the motion is defeated.
I'm just going to leave you with the fact that we have now adopted a motion. I think that's a step forward and was a step that I don't think some of my colleagues probably expected. But I think we're moving forward, and we're going to call a meeting on Tuesday. I will let you guys know what time that meeting will be. But I will check out with everybody's schedule at what time the meeting will be. So I thank everybody for being here. Je vous remercie.
Thank you very much.